Title, and Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Tuesday, June 15th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll do the disclaimer next. Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Retention of jurisdiction, section E on page 255 is where we begin from last time. That's section 72 in general. Section 72 in general. This is the book on equity. It is a general rule of equitable jurisprudence that where a court has assumed jurisdiction for one purpose, it will retain it for all purposes, legal or equitable, connected with the principal controversy. The aim of the court of equity is to administer complete relief in a single unit, and as a general rule, the court will in one suit investigate and determine all questions incidental to the main controversy and grant all relief incidental to accomplishment of the principal object of the bill, even in those respects in which it would not have had jurisdiction originally. So it is a well-established rule that a court of equity which has obtained jurisdiction of controversy on any ground for any purpose will retain such jurisdiction for the purpose of administering complete relief and doing entire justice with respect to the subject matter, particularly with respect to the enforcement of its own decree. And this is true whether the question is of a remedy or a distinct yet connected topics of dispute, and whether the rights and remedies involved are legal or equitable. In explanation of the rule, it has been said that while equity is reluctant to assume jurisdiction, once it has done so, it will jealously guard its jurisdiction, that the powers of equity court are coextensive with the rights of the parties to the suit and the subject matter involved, and that equity will not alter a party or a partial or incomplete decree. This doctrine seems to have grown out of the equitable jurisdiction of purposes of discovery and rests on the same principles which permit a court of equity to take jurisdiction in the first instance, because the remedy at law is incomplete or to avoid a multiplicity of suits. The rule has been said to rest on the fundamental concepts that equity will not suffer a wrong to be without a remedy, and that equity delights to do justice and not by halves. The rule is not an inflexible one which the court of equity is bound to follow in every case that comes before it, and it is permissive rather than preemptory in character. The extending of the jurisdiction of equity
so as to include all the points of controversy rests largely on the sound discretion of the Chancellor, especially so where the rights involved grow out of other contracts. Moreover, the doctrine is subject to an important limitations, and in its application care must be taken not to violate the basic laws of pleading. And in this respect, it has been held that the rule that jurisdiction will be retained to adjust all controversies between the parties is applicable only as to matters sufficiently presented by the pleadings. It has also been held that equity will administer complete relief on all questions properly raised by evidence regarding whether they are specifically raised by the pleadings. The doctrine that equity will retain jurisdiction to determine all matters and controversies will not be applied to deprived litigants of their fundamental rights, such as the right of election or choice between different remedies and the different forums. For the rule as to disposition of all matters can be applied, some ground of equitable jurisdiction must first be asserted and established. It must appear that equity jurisdiction was rightfully invoked, and the subject to be adjudicated must be something incidental thereto or so closely connected therewith as to render its determination necessary to a final decision of the whole controversy between the parties. The fact that necessity for relief originally asked may disappear pending the proceedings does not destroy the vested jurisdiction of the court to retain the case for complete disposition of all rights and obligations of the parties. And the court may retain jurisdiction despite complainant's decision at the hearing not to ask for the relief originally sought. And notwithstanding, one of the parties declares that he does not ask affirmative relief but only wishes to dismiss and left to enforce his rights in some other manner. And although it may be impractical to grant the specific relief asked, or despite the fact that the relief asked is in excess of what the court is justified in granting, the court in such a case retaining jurisdiction and adjusting the rights of the parties may be equitable. The rule extends only to controversies which arise and are submitted by proper pleadings between the parties. It has been held that it will not be exercised but for punitive purposes, nor will it be applied to bring into equitable jurisdiction matters to which another court has exclusive jurisdiction. It has also been held that the rule does not contemplate vesting of power in the court beyond its recognized jurisdiction. Moreover, the rule that equity court may decide all the issues between the parties merely defines equity jurisdiction and the scope of the relief which may be granted, and does not mean that there does not have to be some basis in law or equity for the decision of such issues one way or another. Next subsection, matters occurring after suit brought. The court is not restricted to an adjustment of the rights of the parties as they existed when the suit was brought, but will give relief appropriate to events occurring pending the suit. Next subsection, jury trial. It has been said that equity will not retain jurisdiction for the purpose of depriving a litigant of his rights by trial by jury, and that the trial of the legal matters by jury is essential to relief, or if the issue is particularly more appropriate for jury trial than by a judge, equity ordinarily will decline jurisdiction as to those matters, leaving the parties to their own legal remedies. However, equity may retain jurisdiction and pass on the issues ordinarily tried by a jury, even though the effect is that extent to deprive the litigant of a jury trial. The equity court retaining jurisdiction to dispose of the whole controversy may call to the assistance of a jury to determine issues of fact. Next subsection, incidental questions. In accordance with the general jurisdiction of equity to adjudicate ancillary and incidental matters discussed supra section 9, some courts in stating the general rule have said that equity court obtaining jurisdiction will retain it for the purpose of deciding and disposing of any incidental questions or matters which may arise. Next subsection, nature as ex delicto or ex contra to. The nature of an action is ex delicto or ex contractu. It is not important in the application of principle that equity, having obtained jurisdiction of a case, will retain it to do complete justice. Next subsection, statutory provisions. A rule as to retention of jurisdiction by equity to afford complete relief will not be applied where to do so would be in contravention of the statutory provisions, as where an exclusive remedy is conferred for the infringement of a particular right. However, it has been held that the operation of rule is not precluded by statutes creating cumulative remedies or dealing with parties. Further, it has been held that the provisions of the Codes and Practice Acts, which reference to the joinder of causes of actions and counterclaim, have not changed the rules as to the retention of jurisdiction in equitable action, notwithstanding the rule that equity, having assumed jurisdiction of a case, may retain it to do complete justice, is frequently applied to jurisdictions where, under the Codes and Practices Act, issues at law and equity may be tried before the same tribunal and the same action. It would seem that there would be no necessity for its application. Next section, 73, complete equitable relief. Under the general rule, a court of equity whose jurisdiction has been invoked for one purpose may determine all equalities existing between the parties in connection with the main subject of the suit, so far as authorized by the pleadings, and the equitable relief may thus be incidentally obtained even though the original bill would not lie for such relief alone. By virtue of the rule stated in the preceding section, a court of equity, when its jurisdiction has been invoked for any equitable purpose, will proceed to determine any other equities existing between the parties connected with the main subject of the suit and granting all relief necessary to the entire adjustment of such subject, provided as authorized by the pleadings. Relief of an equitable character may thus be incidentally obtained when an original bill would not lie for such relief alone. Next subsection, where main purpose of bill fails. Even when the plaintiff fails to sustain his bill for his principal purpose, the court may, on proper pleadings, retain it to adjust such equities as do appear. Next section, 74, legal relief in general. A chancery court may retain jurisdiction of a case of original equitable cognizance to afford legal relief, but retention of such purpose is a matter of discretion rather of right and will ordinarily be denied where the legal relief is not germane to the equalities involved. It is a general rule that where the controversies require any purely equitable relief, such as will give the court of equity a right to act, the court will proceed to a final determination of all the matters at issue, and in doing so, it may establish purely legal rights and grant legal remedies which would otherwise be beyond its power, such as rendering personal decrees for money or as damages for breach of contract as considered infra section 76 and 77. This doctrine prevails not only in code states, but also in states where courts of law and chancery are separately maintained. The rule is not, however, of universal application. Whether the court will so proceed to fundamental determination of legal rights is a matter of sound discretion, which will ordinarily be exercised by retaining the cause and granting any necessary legal remedies. Next subsection, limitations on rule. In order to justify retention to grant legal relief, 1, there must have existed an equitable cause of action growing out of the transaction prior to the commencement of the action, which must be both alleged and proved. See infra section 78. And 2, that in accordance with the general rule discussed infra section 82, the legal matters adjudicated are germane to or grow out of the matter of the equitable jurisdiction and are not distinct legal rights not affected by the adjudication of the equitable questions involved. And 3, that the court has acquired jurisdiction of the parties or res necessary to the exercise of its actual jurisdiction to grant at least some of the equitable relief proper under the allegations of the bill. In order for a court of equity to retain jurisdiction, the legal demand must be incidental to equitable relief. The rule as to retention of jurisdiction does not extend to the case where only some incidental matter is of equitable cognizance, and thereby enable the court to draw in a main subject of controversy which has a distinct and appropriate legal remedy of its own. Next subsection, counterclaims. The court of equity is empowered to hear and determine counterclaims of a legal nature. Let me read that again. A court of equity is empowered to hear and determine counterclaims of a legal nature. Next subsection, remedies ordinarily granted by special proceedings. A court, having once taken rightful cognizance of a cause, is empowered and required to afford complete relief, even though it incidentally involves granting of a remedy ordinarily administered by a court in a special proceeding. Next subsection, alternative legal relief. Courts endowed alike the powers of the chancellor and the court of law may, on a given statement of facts constituting but a single wrong and showing plaintiff has enabled to relief either in equity or at law, grant proper relief at the law where it appears that under prevailing conditions it would be impractical to award equitable relief, but it has been held that the court is without power to award both legal and equitable relief. Next subsection, defenses. It has been held that when a court of chancery retains jurisdiction to administer legal rights and remedies, it acts as a substitute for a court of law, and that the defendant should be permitted to interpose any defense he could have urged and the case be transferred to the law side. Next section, 75, delivery of real or personal property. In a proper case, an equity court retained jurisdiction to afford complete relief may decree delivery of a possession of real or personal property, notwithstanding the refusal of equity generally to decree the delivery of the possession of land, as discussed supra section 29, as delivery will often be decreed for the purpose of affording complete relief when a resort to equity has been necessary in order to establish plaintiff's title or right of possession. The recovery of land should be not merely collateral but incidental to the equitable relief, and the rule prevails with regard to chattels. Next section, 76, decree for money generally. Under the doctrine of complete justice, when it has assumed jurisdiction, equity in a proper case may be an incident as its relief and enter a decree of money. While equity ordinarily will not entertain a suit seeking money decree, as explained supra section 26, a decree for a payment of money, although as in a power of a law court, is appropriate to equity in carrying out the policy of doing complete justice where once its jurisdiction has attached. As an incident to other relief properly cognizable in equity, the court may retain jurisdiction and compel an accounting between the parties, as shown in CJS Accounting Section 28. Sometimes the court will go beyond an accounting consistent with the determination of the main equities involved and will award monies accruing somewhat collaterally but connected with such equities. Under proper circumstances, the court may retain jurisdiction until complete justice has been done by sale of land and distribution of the proceeds. Although the recovery of money is ordinarily a matter of purely legal cognizance, it's shown in supra section 26. When a court of equity has taken jurisdiction to set aside a title, it may take an account of rents received through which such title and award them to the rightful owner. Where special circumstances exist and are alleged, calling for equitable relief, the suit to recover judgment and for money due on a negotiable instrument may be in equity, as where a discovery is sought, or where plaintiff's title is equitable. Where the court has jurisdiction to determine the question of fraud in the first instance, it may retain such jurisdiction and require restitution of money paid out in reliance on fraudulent decree, but the court is not required to render a judgment on the alleged claim of one of the parties where no evidence is introduced which will justify the court in rendering judgment for any specific amount, and in order to render a judgment at all, the court will be required to hazard a guess as to the amount due on the claim, if any. Next section, 77, damages. The rule that court of equity assume jurisdiction of a case may retain it to do complete justice has been applied so as to permit retention to award damages as for breach of contract or tort, provided such damages are incidental to the main purpose or ground of equitable relief. Under the rule that equity having assumed jurisdiction of a case may retain it to do full justice, the court may in proper case allow recovery of damages. So it is proper for the court to ascertain the award and award the damages following from the wrong, which is the basis of equitable relief, and where where jurisdiction has been invoked to restrain the further commission of wrongful acts, damages already suffered will generally be awarded. An application to the rule permitting equity to retain jurisdiction and an award damages incident to doing complete justice between the parties, damages in a proper case be awarded for breach of contract or tort, and under such rule, equity may, where the circumstances warrant, award damages for conversion, fraud, libel, and slander, nuisance, trespass, or waste. Retention of jurisdiction to award damages is, however, matter of discretion rather than right. The courts of equity retain jurisdiction to do complete justice, award damages only when good cause of action has been made out under established principles of jurisprudence. Damages recoverable in equity as incident relief ordinarily are limited to compensatory damages, and where there is some authority that punitive damages may be awarded, the general rule as shown in CJS Damages, Section 117, Subpart 1, is that equity will not award exemplary or punitive damages. Ordinarily, equity will not retain jurisdiction to award damages unless such damages are ancillary or incidental to some principal ground of equitable relief. And as a rule, equity will not retain jurisdiction for the sole purpose of trying a damage suit. It has been held, however, that where granting of equitable relief appears to be impossible or impractical, equity may award damages in lieu of desired equitable remedy, and there is authority to the effect that where relief particular to equity is refused, jurisdiction may be retained simply for the assessment of damages. Next subsection, damages penitent light. In some cases, it has been held that damages down to the time of the trial may be recovered. In others, it is held that damages can be recovered only in a commitment of the suit. Next section, 78, where equitable relief denied. The general rule, although there is some authority to the contrary, and some well-recognized exceptions, is that equity jurisdiction will not be retained to grant relief, legal relief, where no right to equitable relief is established. The rule considered in the preceding sections that where the equitable jurisdiction of a court is once brought into action in a proper case, the court will retain jurisdiction of the parties and subject matter in order to do complete justice to all concerned, even in some instances to the extent of enforcing purely legal rights, applies as a general rule only when the court retains the original case in order to grant some substantial equitable relief. Where the bill on its face discloses no equitable ground of jurisdiction, no relief whatever can be granted where the court or the procedure in law and in equity are distinct. And even where the bill states a case entitling complainant to equitable relief, if the proof fails to establish the averments of the bill, in that respect the court is without jurisdiction to proceed further and determine rights which are properly cognizable in a court of law. In other words, equitable rights must be both averred and proved before purely legal rights will be determined by a court of equity. Sometimes without denying its jurisdiction, the court states the rule less positively, and that the bill will not be retained, or that plaintiff is not entitled to its retention. A contrary rule is recognized in some jurisdictions, however, that a court of equity may give judgment of legal relief which contemplate the complainant is entitled notwithstanding he fails to establish his rights to equitable relief, and further requirement being opposed in some jurisdictions as the action in equity shall have been brought in good faith. In other jurisdictions, under the influence of provisions of the codes abolishing the distinction between actions at law and suits in equity, under which there has been but one court and one form of action in which the judgment may give all relief either in law or in equity, to which a party may show himself entitled, it has been held that upon to the point where constitutional right of trial by jury would be unduly prejudiced, by going further, there was no want of power to grant legal relief to the action commenced to secure equitable relief only, and this is true notwithstanding the facts of the case were known to plaintiff where he commenced his action for equitable relief. The rule denying relief where the right to equitable relief is not established has been applied where the proof shows the plaintiff's conduct prior to the beginning of the suit was preclude him from the right to ask for relief, or where equitable relief is refused for illegality, fraud, or bad faith in the transaction. On the other hand, even in jurisdictions which in general adhere to the rule denying legal relief, there are circumstances under which the court will grant compensation in money ordinarily obtainable at law on denying equitable relief. One of these cases is that which plaintiff establishes equity, but equitable relief is found impractical or unjust in the particular case, and the damages awarded in lieu of equitable relief, which might have been decreed. Other instances are cases where the remedy at law would be doubtful or inadequate, where the remitting the parties to the court of law would necessitate a multiplicity of suits, and where the equitable features of the case is not available to the establishment of the defense thereto, or where to remit complainant to his action at law could be the requiring of a useless act where the question of law only would be involved which has already been passed on the Chancery Court, the same judge would pass it on to the action at law. It has also been held that retention of jurisdiction will not defeat a judgment where there is no objection and no obvious reason for a jury trial. Next, section 78, where equity fails after suit brought. Ordinarily, jurisdiction is tested by the facts and they appear on the inception of the suit and will be retained, although subsequent events may render equitable relief unnecessary or improper. The test of jurisdiction of a court of equity is whether facts exist at the time of the commencement of the action sufficient to confer jurisdiction on the court. If plaintiff is then entitled to the act of equity, the jurisdiction will not be defeated by subsequent events which render equitable relief unnecessary or improper, or where plaintiff has established his equitable but need for equitable relief has ceased pending suit or has become impossible as distinguished from improper. This rule is applicable not only where the relief sought is to prevent action from the defendant, but also where the change of circumstances arises from a lapse of time, rendering the specific relief unsuitable or inequitable. On the other hand, the jurisdiction of the Court of Chancery does not exist when the whole foundation on which it rests is either disproved or shown to be a colorable disguise for the purpose of changing the form of litigation. And when its jurisdiction fails, all power of the court also fails except to give judgment for costs. Bills concerning the title or right of possession to land have been dismissed where, after suit brought, ejectment became available as an adequate remedy, where a necessary party for the purposes of equitable relief dies pending the suit, and the plaintiff fails to relieve it against his representative, legal relief will not be granted against the remaining defendant. Next, section 80, incidental determination of legal questions and title. Where equity has jurisdiction of a suit primarily of equitable cognizance and may retain such jurisdiction for determination of incidental legal questions which may arise, but if the primary question is legal and equity is involved only as an incident, the court will generally refuse to settle the legal question. Where a court of equity has assumed jurisdiction of a cause, it will ordinarily hear and determine incidental legal matters, and except where the jurisdiction of the equity depends on the prior establishment of a right at law, will try and establish legal rights or title where equitable rights depend thereon. Moreover, the jurisdiction of equity having once attached is not lost because courts of law subsequently acquire a like authority. On the other hand, a party seeking secondary equitable relief is not thereby privileged to withdraw cognizance of the cause of the legal form for determination of equity, and the right to incidental equitable relief does not draw to equity cognizance over controversies alien to its method of procedure. Next subsection, title to land. Courts of equity do not, as a rule, intervene merely to test legal title, especially by injunction or substitutive ejectment, as shown super in section 29. But it does not follow the legal titles will never be determined in equity. In some cases where equity has acquired jurisdiction for equitable purposes, it may be necessary in order to do complete justice to determine legal titles or decree the delivery of possession of lands, although the rule is inapplicable where the bill seeks only to have the legal title determined and declared, and if the equitable relief sought is merely secondary to the establishment of legal title, equity may decline jurisdiction and relegate complaint to law. The equitable relief must be something more than simply an aid of a legal action or during its pendency. The equity to an injunction against trespass or waste will not confer jurisdiction to try legal titles where plaintiff is out of possession and therefore can try his title at law. Relief of the character obtainable in ejectment has sometimes been denied even in cases where equity would ordinarily retain jurisdiction for the purpose of a complete adjustment of the controversy. Next subsection, title to office, elections, where in a suit of which the equity has jurisdiction, the question of the right to an office or the regularity of an election arises but must be decided to obtain the equitable relief. The court has power to inquire into and decide these matters for the purpose of the suit, but the decision is only for the purpose of the suit, and it does not settle the right to the office, vacate it if the party is in actual possession. Likewise, the court may incidentally determine the location of the property seat, although such determination requires an inquiry into the firmness of the election for the removal of the county seat, or in a proper case may order a new election of officers. Next, Section 81, relief to defendant. The rule that equity, having assumed jurisdiction, may retain it to adjust all claims applies to permit retention of legal or equitable claims germane to the original bill and arising on behalf of the defendant against the plaintiff or against other defendants, although some particular relief in equity may be denied defendant where the original bill lacked equity and a counterclaim is determinable at law. The doctrine of retaining jurisdiction in order to completely adjust the controversy extends to the granting of relief to the defendant or between co-defendants. On this ground, defendant may have relief to which he shows himself entitled against plaintiff, although he does not ask for it. And even in some cases where plaintiff has failed to make out his own case, under some circumstances, defendant may thus obtain relief in the absence of facts essential to the maintenance or the original bill for the purpose. Where the original bill presents questions of equitable cognizance, defendant may have legal relief against the plaintiff. Where, however, the original bill lacks equity or equitable relief is denied, according to some authorities, the cross bill fails with it, unless it contains matter of equitable cognizance, and in which case the cross pleader is entitled to his equitable relief or even purely legal relief, where such legal relief relates to the subject matter of the original bill. According to other view, on denial of equitable relief to plaintiff, the court may nevertheless retain the case and grant purely legal relief to the next subsection, rights of defendants among themselves. Rights of defendants among themselves are governed by the same principles as cross relief against plaintiff. Several defendants may cross-plead with each other and have all rights between them germane on the subject of the bill determined, but the relief which may be granted to one defendant against another is only such as incidental to his defense, and where the plaintiff is not entitled to relief against either defendant touching the subject matter in dispute, one defendant may not have relief against his co-defendant touching the same subject. It has been held that the rule that a court of equity will adjust the entire subject of the action is subject to the qualification that under statute, when rights between defendants are involved, it is not proper to make a determination thereof unless demanded in the pleadings. Next subsection, where defendant injects controversy into suit. Where a defendant injects controversy into the suit, plaintiff may have appropriate relief relating thereto, although he does not ask for it. Next subsection, transfer from law to equity. On a transfer from law to equity, after the defendant has tendered an equitable issue to a complaint at law, equity having assumed jurisdiction will retain it to dispose of all issues, or on finding against defendant on the equitable defense, allow the case to proceed at law. Section 82, independent controversies. The rule that on assuming jurisdiction, equity will retain it to do complete justice is limited to its application to matters germane to the principal controversy, and ordinarily does not extend to retention of independent controversies. The doctrine of retaining jurisdiction to settle an entire controversy is confined to the determination of rights dependent on, or at least germane to, the subject matter and main purpose of the bill. Jurisdiction will not be retained to adjust independent controversies between the parties or controversies beyond the scope that is beyond the scope of that raised by the bill. Next subsection, enforcement of judicial bonds. The Court of Equity will retain proceedings on nec sit bond and enforce the liability of the obligors. Proceedings on a bond for the payment of maintenance, however, will not be retained in chancery, but the obligee will be required to sue at law. Where a Court of Equity has taken jurisdiction of the suit by sureties to enforce a supersedeas bond, you will retain jurisdiction to settle the whole controversy. Next section, 83, special applications of rule. The rules under considerations have been applied to permit equity to afford relief of many and various kinds. And for example, where jurisdiction has been obtained in connection with a bill for discovery and notwithstanding relief may be had in another proceeding. The arm of equity is long and its limits undefinable, and it has been obtained where it has obtained jurisdiction in the first place, it will retain it to administer complete relief by whatever means such relief may be achieved, whether by acquiring specific performance, payment of money, execution of a deed, or any other thing. Whether the justiciable controversy is presented, the name of the relief sought is immaterial. Next subsection, bills of discovery. The bill that equity having acquired jurisdiction will retain it to afford complete relief may be applicable to the jurisdiction to obtain in connection with a bill for discovery. As where under such circumstances, the Chancery Court awards legal relief. Other courts have held that where a party comes into equity for discovery merely and is in the ground that where the court obtains jurisdiction and no other equitable relief is or can be sought, the case will not be retained for the purpose of assessing damages, but the parties will be remitted to the action at law, and that the one seeking only secondary equitable relief through a bill of discovery is not thereby privileged to withdraw cognizance of the cause from a legal forum for determination of equity. A bill for discovery to obtain evidence in an aid of a legal action does not draw the whole case into equity, but the jurisdiction ends with discovery. Next subsection, effective pending legal action. Equity jurisdiction is not lost because of adequate legal remedy, because available after the filing of the bill, and where circumstances exist justifying a court of equity which has properly acquired jurisdiction and retaining it to enforce legal remedies, such course may be followed, although an action at law is pending where the rights might be determined, and thus whether such legal action is instituted after or before the jurisdiction of equity attached, although it has also been held that where an action at law has been brought in a state court, a federal court will not entertain jurisdiction in equity of a suit covering the same controversy if no right to equitable relief is shown. Next section, F, jurisdiction of the person and of property or other subject matter. We will pick up there next time. That starts on page 273 under section 84 in general. We'll pick up on F, jurisdiction of the person and of the property or other subject matter on the next show. So let's start the Q&A, and you'll have to
Q&A session started.
press star 6, star 1 to raise your hand and get in the queue. Press star 6 and star 1 to get in the queue and raise your hand. Okay, we've got Michael, you're unmuted.
Yeah, can you reread 77 again?
77?
Yeah. Please.
Damages. The rule that a court of equity assuming jurisdiction of a case may retain it to do complete justice has been applied so as to permit the retention of reward damages for breach of contract or tort, provided such damages are incidental to the main purpose or ground of equitable relief. Under the rule that equity having assumed jurisdiction of a case may retain it to do full justice, the court may be in a proper case allow a recovery of damages. So it is proper for the court to ascertain the award of damages flowing from the wrong which is the basis of equitable relief, and where jurisdiction has been invoked to restrain the further commission of a wrongful act, damages already suffered will generally be awarded. In the application of a rule permitting equity to retain jurisdiction and award damages in incident to doing complete justice between the parties, damages may be a proper case be awarded for breach of contract or tort, and in such a rule of equity may, where the circumstances warrant, award damages for controversy, fraud, libel, and slander, nuisance, trespass, or waste. Retention of jurisdiction to award damages is, however, matter of discretion rather than right. The courts of equity retain jurisdiction to do complete justice, award damages only when a good cause of action has been made out under established principles of jurisprudence. Damages recoverable in equity as incidental relief ordinarily are limited to compensatory damages, and while there is some authority to that punitive damages may be awarded, the general rule as shown in Corpus Juris Secundum Damages, sections 117, subparent 1, is that equity will not award exemplary or punitive damages. Ordinarily, equity will not retain jurisdiction to award damages unless such damages are ancillary or incidental to some principal ground of equitable relief, and as a rule, equity should not retain jurisdiction for the purpose solely of trying to damage suit, and has been held, however, that where the granting of equitable relief appears to be impossible or impractical, equity may award damages in lieu of the desired equitable remedy, and there is authority to the effect that where relief particular to the equity is refused, jurisdiction may be retained simply for the assessment of damages. Damages pendent light, and in some cases where it is held that the damages down to the time of the trial may be recovered, and others is held that damages can be recovered only to the commencement of the suit. And that takes us to the next section.
Okay, thank you. No questions.
All right. All that, no question?
Well, it's somewhat at the discretion of the judge, it sounds like to me. If we can prove that there was a breach, then basically he will reward, what we requested from the very beginning, whether it be return of all the trust res or terminating the trust or whatever the case may be, whatever our original order was. Is that correct?
That's kind of what I read there.
Okay, that's all I wanted to know. Thank you.
Well, it's not a strict and hard, fast rule.
Mm-hmm. Okay. Thank you.
Okay, press *6, *1 to get in line for the queue to raise your hand. 353, you're on.
Hey, Christian.
Hey. Dominic.
Hey, how you doing? Hey, how you doing, Dominic? Good. Christian, I have some great excerpts tonight from CJS. I'm just filling in some gaps here on an equity suit procedure, and I just want to bounce a few things off you regarding a counterclaim. The counterclaim stated will have on the original claim it was the governor of XXX Bank, we'll say, versus the strawman. In the counterclaim, it's basically going to be the parties to the trust, isn't it? It's going to be specifically the CEO that's going to be mentioned on it, and the settler, correct?
Well, the complainant will be the beneficiary, but since he can't come through the trustee because the trustee is the one that's done the breach, then he can come through in his own name, his own right. And the other party would be the named trustee who's in the breach then.
Okay, so he would be the person that would have received the instructions, like, yes.
Yes.
Okay, which would also obviously be working for that particular bank. And you're saying the person making the claim would be the beneficiary, so?
Right, unless the grantor established himself with some kind of co-beneficiary rights.
Okay, all right, okay. No, on my paper, on the paperwork I sent off originally, I stated myself as settler, as grantor settler, and obviously the beneficiary would have been the what debtor creditor calls the strawman. So effectively, I am pretty much both parties.
Yes, if that's how you're playing it, yes.
Okay, so I can put him down. So see. Okay, fine. Now you just read out there about damages and equitable relief. We're not seeking damages as such, which is the remedy at law, but we're seeking equitable relief, which is basically whatever we stipulated in our orders or in our instructions. So in this case, it would be obviously the return of the special deposit or the carrying out of the orders. Now, if they don't have the special deposit, will damages come into play?
Damages could be awarded by the court if they want to give you a complete remedy, but that would be discretionary for the court. But like you said, I would come in just with the enforcement of what you're trying to enforce.
Okay, because we all know that it's not likely that they're going to return the ST because they obviously can't return it.
But if you don't ask too much, you get more than what you wanted in relief. So I would hold it just under an equitable claim without any at-law things that get you thrown back in the at-law side. Just
Yeah,
stick with
fantastic.
Just stick with the equitable relief.
Yeah, no problem. No problem. I just have a few bits here, Christian, if you don't mind. Okay, that's fine. Fraud is an equitable tort of deceit, isn't it?
Yes, so's mistake.
Mistake. Okay.
Reform or modify or revoke it.
And fraud is effectively breach of trust.
Yes and no. Let's put it this way. It's under equity, but it comes under one particular division of equity, because equity has two divisions. The subject matter is trust under equity, and that's solely where trusts have their remedy, and that's solely where they operate in their equity. But there are other equitable reliefs, and those come under fraud, mistake, breach of performance. So there's your two divisions. But the one division is solely trust. The other one's enforcement of performance according to fraud, mistake, and things. There's your two divisions of equity.
Okay, so somebody not carrying out the specific instructions to merge titles and effect payment, that's basically breach of trust, so that would come under fraud as well, obviously, because it's an equitable.
Yes and no.
Okay.
Yes, under the second division, but the primary division that we want to stick into as much as we can is what?
It's trust, obviously, yes.
Yes, trust. We want to stick in the NTT side. We want to stick solely under the trust division of equity.
Okay.
And what does that have to do with? What are we going to plead? Just like in the movie The Wizard of Oz, she clicked her heels 3 times. Rights. What does equity have to do? It's got to do with everything with rights.
Okay. Okay. I got you. Yeah.
So we need to make sure that we are enforcing or coming out with a relief for an enforcement of a right under trust. We do not want to argue their at-law side. You don't have to, especially if you've got a counterclaim, because counterclaims in equity also. So I'm afraid what most people are going to do is they're going to get stuck and traverse into the case by arguing their facts at the at-law side on the claim side, on the plaintiff, rather than coming in and argue their side of the case on the counterclaim in equity for the enforcement of a right. Why didn't he do what he was supposed to do, in other words? What I want the Court of Equity to enforce. And as long as you make a prima facie case, the Court of Equity is going to consider him to be guilty and wants to know when's he going to do it. In fact, it's going to force him to do it if he doesn't have a record that he's already done it.
So the Court of Equity is just basically concerned about when is this guy going to make a payment.
I think everybody is shaking in their boots afraid about this stuff because they really don't understand the flip-flop from at-law to equity. They're worried about what happens at law when in equity none of that stuff applies.
Yeah.
The proof shift from at-law to equity to where all you have to do is make a prima facie case for trust. And the burden shifts to the trustee or whoever that he breached.
Okay, so you're saying basically not to get caught up in the at-law side, just let equity do its job.
Yeah. Equity will do its job.
Yeah, because as I said, my counterclaim is obviously I'm coming in from the colorable side. It's like an equity suit action, and I was just going to come in under fraud. You know, just to get in, like I said, on that side, just to bring me into equity. That's why I just asked.
When they say something, plaintiff says something, well, you know, Your Honor, what's that got to do with my counterclaim? What's that got to do with enforcement of my right? Are you going to argue rights, or are you going to argue facts? Because that's going to determine what side of the court you're going to be on, at law or in equity.
Yeah, okay. Cool. What else have I got here? There is no need to send off any private paperwork while I'm coming in with a counterclaim, is there, to the judge? Example, protective order.
When we first started out, we thought it was necessary for a protective order, but, you know, if you're not talking about the case, substantive rights, the facts, your SOIs to support your equitable claim, then you won't waive them. That would only be in the in-camera evidentiary hearing, where you want to present your SOIs. So
And
yes,
obviously that's something
to put your evidence in the place where you're going to be able to, you know, in judges' chambers for the in-camera review.
And this is something that you can do in court, obviously. If you're in court. Before, okay. Okay, cool. Now, going in, I heard you stating on a previous call as well, Christian, going into court, posture in court. Obviously, we're not going in as defendant because that's the creditor side and that's the at law side. We're going. I heard you mention.
Why am I not going in as defendant? Why am I not going in as defendant?
Well, because the defendant is guilty and you're not guilty and you're settler.
No. Well, how come I'm not the defendant?
Because you're going in under a counterclaim. You're going in as plaintiff.
Yes. What happens on the counterclaim?
Well, the counterclaim is usually heard first, isn't it?
Yeah. But what happened on the captioning on the complaint, on a counterclaim? Who's defendant on the claim?
The original plaintiff. The tables are turned.
Claim is the original complaint. On the original complaint, on the claim, who's the defendant?
Me.
Yes. On the counter complaint, which is the counterclaim, who is the defendant?
There.
See. Who's plaintiff?
I am.
You are. Got it.
Yes. Okay, so that's my answer. I'm plaintiff. Okay. Cool. Just talking there just a second ago of just about the counterclaim form itself, the structure of it. It's broken down into two sections, Christian. Endorsement claim and jurisdiction claim, and the final one is equitable relief. This is where I'm slightly confused again, because I'm in when I'm filling out the endorsement of claim, I don't want to make this a complicated thing. Obviously, I just want to put in something simple, something like, I'll stick to the language like the defendant has brought fraud upon the court, whatever, by filing a fraudulent claim on the following accounts, etc.
You're arguing facts. You're arguing facts
okay.
on their claim.
Okay, I'm back to that again. So okay.
Yep.
All right.
Old ways die hard. We always want to prove ourselves right, have the last word, and always want to fight.
Okay.
What is your main focus in equity under trust? Why are you there?
I'm there to get equitable relief.
On what?
I want a return of my special deposit.
What's that?
Trust.
What's that?
It's trust property.
Well, under the court terms, what is trust all about? Duty, obligation. What's that?
Well,
beneficial right.
Okay. Yep.
You've got rights
Beneficial
that
rights.
the trustee owes to you. You've got a duty. He's got an obligation that he owes to you. You have a right.
Mm-hmm.
Don't argue facts, especially their facts.
Okay.
Argue your rights.
Okay.
What they have on the plate is underneath yours. What you have on top is yours. Argue yours. If you don't argue yours, you're going to lose. Corpus Juris Secundum, or it's not Corpus Juris, Black's Law, 8th edition, trust, definition. About into the small print there, 1, 2, 3, third paragraph. It says some courts, the legal writers have defined a trust as a certain kind of right that the beneficiary has against the trustee, and a certain kind of interest that the beneficiary has against the trustee, or a certain kind of interest that the beneficiary has in the trust property. That's title. There's your rights, title, and interest. Argue those. Those are your rights.
Okay.
Bring in your facts to state that.
Okay. Stay away from arguing the facts. Just focus on the rights. On the rights of the beneficiary, that is.
And don't let them argue it for, because they will drag you right back into their claim, and you'll be right out of your counterclaim.
Yeah. Okay. The question is, if in court, whatever paper, whatever, and they say we haven't received payment, obviously I won't be discussing that in open court. That's something for private chambers only. I'd be correct in saying that, wouldn't I? Yeah.
Well, it's like, well, you haven't received payment. I guess that's why we're here. But that's my issue. I have a right that this fellow was supposed to make the payment. I want to know how come he didn't make the payment. Because he owed me the... And that's what we're here for.
Cool. Fantastic. Thank you, Christian. Thanks for clearing that up. I just had a few small bits there. I just needed a bit of clarification. I was way off. Obviously, I was arguing the facts there, and
yeah.
Obviously, I shouldn't have been.
Want to argue what they bring on a piece of paper where it has a bunch of fraudulent lies on it? No, bring in your truth and argue your facts.
Okay.
Chambers.
Fantastic. Fantastic. Thanks, Christian. I appreciate your help. Thank you.
Thanks, Dominic. Next caller, you're muted, Jeff.
Yes. Hey, good evening. Thanks for taking my call.
Go ahead, Jeff.
Can you hear me?
You're kind of crackly, though.
What's that?
A little crack. Go ahead.
Okay. So let's see here. So rights, title, and interest, that basically is the rule of equity, basically having...
Well, that's the rule under trust, under equity.
Yeah. And to invoke equity, it's just basically by doing it. He who claims equity has to do equity.
That's one of the equitable maxims, yes.
Okay, so it's kind of like this invisible, you're switching from that law into equity in the courtroom.
Yes.
Essentially.
You're invoking equity.
Yeah,
You're like flipping the switch.
Yeah, and just by your actions, it's the conduct that creates the equity in the courtroom.
It starts with the pleading. It first starts with the pleadings. You have to have a equitable, cause of action.
Okay.
But that's with the switch that throws it into equity, or that's how you invoke equity.
Yeah. So it's the pleadings, the way the pleadings are written.
Yes.
Okay. All right. So okay, and that essentially is by bringing in the trust or evidence of the trust, essentially in your pleadings.
Yeah, he who claims trust has to prove trust.
Right. Same with equity. Who claims equity has to basically act in equity. Okay.
If I claim trust solely operates in equity.
Right. Okay. Of course. All right. So this is an ambassador call, and I was hoping to maybe work a little bit more with somebody. I just want to put my information out there if that's possible.
Yeah. Go ahead. Mm-hmm.
Okay. My email is Organica, LAORGANICALA @gmail.com. So, and also I'm on Skype as Organicali. I've been studying a lot lately. I'm really trying to switch from the creditor-debtor mentality of, which I assume is at law, like once again, into just pure equitable trust. So, there's a lot of different information out there, and it's really just trying to pick your actions and how to pursue them properly. Seems like.
That's how they're getting us. Yep.
Yeah, and what if the judge doesn't want to grant you a
force, whatever it is if they claim it is, whether it's admiralty or whether it's breach of statutes and codes or whatever they want to call it.
Well, they'll never admit that admiralty. If you ask them if it's an like, are we on the sea? They always deny that they're in admiralty law. They're not going to recognize it. They will never recognize it.
What it is.
Yeah, it doesn't. I guess it's kind of irrelevant. It's relevant, but not really. If you're doing equity, who cares what they want to do?
Yeah, I'm not in commerce and equity.
Yeah, got it. Equity is it's separate from common law, though, obviously.
Yes, it's separate from common law. It's two different realms.
Right.
Page 19 in Lewin on the Practical Treatise on the Law and Trust, it says that if there are any discrepancies between common law and equity, equity shall take precedence.
Yeah, so they're just the original bodies of law. Okay.
Now, equity is the law of nature, and the law of God is common law. But the harshness of the law is equalized by the equitable smoothing out. But they function hand in hand.
Yeah. And now, writing a counterclaim, is that really is that necessary to get the remedy, you think, or because that seems more like a common law?
Or you got to get through the door, and you can't get through the door unless you've got the right counterclaim.
Yeah. So that's once again your pleadings. You're writing a counterclaim.
Yeah, it's like if you want the door of equity to get in. The path to get in is you got to have an equitable counterclaim.
Yeah.
Equitable. Once you're inside, you're in court. But now you got to go through this other door to get into equity in chambers to get your evidence in there, or else you're on the at-law side as soon as you walk in the door. And if you stay in there, you're gonna get beat up.
Yeah, it's like the lion's cage. What if the judge doesn't want to grant you a in chambers in-camera hearing?
Well, then because you didn't do it right.
Yeah, that makes sense. Got it.
Either you didn't have any equitable evidence to put in that was supposed to be for the case, or else you didn't call your hearing right or something.
Makes sense. And the difference between in-chamber and in-camera is just the clerk, do you know?
Well, no, it's not just the clerk.
Or a court of record, I guess there's a person taking records.
Well, the in-chamber hearing could be out in the hallway between you sitting on the bench and the plaintiff.
Yeah.
Or it could be in an open courtroom when the judge says vacate the thing and there's nobody else there.
Okay, yeah. And then is in-camera usually in the judge's quarters?
No, it could be out in the hallway.
Yeah. So same with that. Okay. All right. So once again, I'm sorry, the difference between the in-camera and in-chambers?
There is no difference. They're synonymous.
Oh, they are the same. Okay. Same.
Yeah, get a Black's Law 8th edition or something and look up in-camera hearing, in-chambers hearing.
Yeah, okay, we'll do that. They're basically private hearings, essentially.
Yes. There should be nobody else around. Now, why are they private? Because you've got confidential information that needs to be kept private.
Yeah.
And if there's nobody else in the room, then that's probably could be a in-camera hearing or an in-chambers hearing. But if you've got other people in there in the court and we start talking about confidential information, somebody needs to start objecting you because you got to keep your information private. You have to take steps to protect it. And the first step is you got to object because there's other people here listening and there's no degree of confidence. No confidentiality here. And then you may have to put in, say, a protective order because somebody wants to talk about this in public. And I don't want to talk about it in public because under Rules of Evidence 501, which comports down to, say, Florida rules, which is 90.501 through 510 under evidence, local rules, especially 90.506 and 507, which is waive your privilege matter upon voluntary disclosure. So I have to be careful about where I'm at because just not any place is going to suffice for me talking about my confidential stuff. It's private.
Well,
I must keep it private. I must take steps to keep it private.
There are players that are parties to the action that are entitled to be there, like the district attorney and the clerk, though, right?
Not necessarily. If I put a protective on there, it might be just for judges' eyes only.
So you don't even have to let the other parties know, the district attorney?
Well, if I've got a trust, he should already know because I've already should have done due process with him by giving him original documents or at least copies of them.
Yes, yes. Okay.
If I didn't, I'm violating due process.
Right, yeah. But then in the final hearing or whatever to get it settled, you can just do that with the judge. It doesn't necessarily have to be with the DA. I mean, isn't that essentially what we're doing is trying to get...
I make the ruling, and he's the guy that I want to be, he's the trier of the facts, and he's the guy that I got to make my case to. But I don't have to make much case because all I need is a prima facie case. This is under trust, and the burden of proof is shifted to the other party, and I want to know when they're going to do the performance because it's my right.
Got it. Okay.
See, we're so brainwashed to going into court at the at-law side and getting all chopped up and mutilated, and then we think that's what's going to happen onto us when we do that. But no, we're not supposed to be at-law. We're supposed to be in the other part, under equity, which is a whole different law form, a different ball game. That's where before you were playing baseball and they were playing football at-law, and now it's switched around. Football, and they're playing baseball, and now we're in equity. Game's reversed.
And that's really just by our pleadings, by producing the pleadings that fall under equity, by producing the documents of equitable.
Yes, and just like the lady asked Franklin, what have you given us? And he says, I've given you a republic if you can keep it.
Yeah.
That's a caveat. You've got equity if you can keep it.
Got it. That makes, yeah. So it's like this invisible world, and it's just by you invoking it brings it back. It's there. It's always there, but we've always just been ignoring it or acting at law and not bringing in equity. By doing equity, we get equity.
Yes, right.
Yeah. It's fascinating. It is the Matrix. It's kind of like the Matrix. It's just really being aware of what you're doing and invoking. Okay. Lots of work to do. I like it, though. Thank you for your work. I appreciate it.
Okay, thank you.
Okay. Bye.
Michael, you're unmuted. Michael, you're unmuted.
Sorry about that. You can hear me?
Yeah, go ahead.
Okay, I got a question in regards to what Dominic, I can't even say his name, Dominic was asking in regards to the counterclaim. What are the words that we put in the counterclaim because we can't divulge that there was a trust? What, we put in there that my rights and interests weren't provided for?
Well, I could put in there that it was a trust, and they may come to the assumption that it was a statutory trust. That would probably get me into equity, and then we could talk about all the other private things with the SOIs in chambers.
So we're saying that the trustee did not perform his duties because the trust was created, or something. Not the trustee did not perform their duties, therefore possibly, or he has breached the trust. That something that simple?
Yeah, because it looks like from what I've been reading, it's just to make the equitable claim for a trust automatically puts it into equity, because that's the only place trusts operate, whether they be statutory or private or whatever.
So we can put in there that there was a trust created and the trustee being so-and-so as...
kind of details, in the pleading so much that I'm going to give away that it's a private trust, say. But I could probably put enough colorable stuff in there to get to come under trust because it is a trust, but I didn't come out and to say what particular type of trust it was, whether it's a statutory public trust or whether it's a private trust under equity.
So then really all we really need to put down that is so-and-so being trustee has refused to do his orders and is in breach of trust. Something that simple.
Yeah.
And then, of course, they will recognize as a trust, and the judge will have all the other documents in chambers that we have already sent to them, so he'll know exactly what type of trust it is, and then he'll basically, when we get into court, look at the trustee and say, why haven't you done what he's instructed you to do?
Yeah, that should be it, really.
And then, if the trustee turns around and tries to bring up all this other stuff, well, you didn't pay this bill, that bill, and everything else, you just look at him. Pardon me?
Why didn't he pay it? Because it was my right. He was supposed to pay it. How come he didn't pay it?
Okay.
He's arguing at me that how come it wasn't paid? How come he didn't pay it? He was the one who was supposed to pay it.
Right. Your rights, him being the title of the trustee, and then your interest because you're the beneficiary, that he's not taking care of your interests.
Yeah.
Correct?
No, he's breaching a trust, yeah.
Okay. All right. Because I know that's where I'm going to be going probably within the next 2 to 3 weeks after I get my stuff squared away, which you're already aware of. All righty. Thank you kindly, sir.
All right.
Okay.
Nobody's in the queue, so if anybody wants to ask a question, press *6, *1 to raise your hand and get in line. *6, *1. Anybody wants to get in the queue line, press *6, *1. Carlos, you're unmuted.
Mr. Christian Waters, what kind of trust? This is Judge Carlos. What kind of trust are you talking about? You're stating that you're claiming a trust. What kind of trust are you talking about? I'm the judge.
The five-letter kind, the TRUST.
Under what law? Or what gives you the right to claim that trust?
Okay, it's like, if we're going to talk trust generally, nobody really knows whether or not we're talking about a colorable trust statutory-wise. That really doesn't really evoke equity, I don't think. It's just a statutory sign.
Right. But I'm the judge playing dumb that I don't know what you're trying to do. So explain to me, Mr. Christian Waters, what kind of trust are you trying to express? Where did you get this from?
Well, there's where I'd have to have my in-camera hearing and set a notice of a hearing that we're going to go and present evidence and prove the trust.
What are you going to prove there? What kind of evidence are you going to bring me so that I can grant you a hearing on camera?
SOIs that I would bring in that proves the trust.
What gives you the right to ask for that? What gives you the right to ask for that?
What gives me the right to ask for that?
Yeah.
Well,
under what
all the rights. That is my right, all rights. But anyway, it's an equitable right.
Who granted to you?
The court does not have to grant me the right. I have the right already, and I'm enforcing the right. That's why I'm in here in a court of equity.
You're trying to express a trust that you don't know where it comes from?
Where does it come from?
Yes. Where did you bring up?
It comes from God. You know, who gives you all the rights?
I never heard about this trust. You're the first guy that I come across trying to express a trust, which doesn't make any sense to me.
Okay, well, let's just...
I've been a judge for 20 years. I never heard this
trust. Are there parties? Is there intent? Is there purpose?
Well, you have to prove that to me.
Yeah,
you're trying to get your home free and clear, and you're trying to express a trust, but you haven't done anything except only trying to express it in camera. What gives you standing for that?
Well, I made on the colorable side a claim for trust, and then I'm proving in chambers the elements necessary to claim the trust and prove the trust.
Okay, prove it.
Well, I've got the documents with me in camera that claims intent, purpose, parties, specific trust res, and
hand them over to the bailiff. Hand them over to the bailiff so I can check them out.
Well, there's where the in-camera hearing comes in.
What gives
you
the
right in-camera hearing? I'll hand them over to you. Here it is.
What gives you the right for asking in camera hearing? Camera hearing is only for private, like private stuff, like trade secrets, I would say. Right?
Yeah, I don't have any trade secrets. I have confidential information.
Confidential information.
Yes.
Okay. So you want me to grant you? You want me to grant you a hearing in camera for a confidential information that you're going to prove to me that you have a trust, you have property in a trust. You want to merge titles in a trust, right?
Yes, but if you don't grant me a hearing, now we got an injustice for being able to prove that I even have a trust. So you got to grant me a hearing.
Under what law?
Under what law? If we don't have an evidentiary hearing, if you don't give me an opportunity to present evidence, we've got a constitutional violation from those guys.
I'm just going to grant it because you're a nice guy, that's all. Well,
the rules are the rules.
Yes.
If we're going to have an opportunity to be heard, I have to have an opportunity to present evidence also. Otherwise,
yes, you're going to be facing all these questions, right?
Avoidable case.
Right. But, and you know, when you were talking on the book, everything makes a lot of sense. And we're talking about trust, I know that. But everything was making a lot of sense pertaining and going back to a foreclosure. Everything was making 100% sense. And I went through the Weisband case from top to bottom yesterday, all night. And I went through the whole case, and they took him months and months to settle, and the homeowner came out triumphant, but he didn't have to go through all that. I'm sorry about crap. He didn't have to go through all that if he had done it the way you're teaching us. That's why I'm trying to, bring up these questions so that some other people can also bring up some questions and feel more comfortable, because we have to through like a mock trial, if we could, in practice, because there's a friend of ours said, you can have all the best documents in the world, you have all the teaching, but if you don't practice, you will lose. I mean,
if you present it, you're dead.
Yes. That's why I want. Is there any way we can do like mock trials and plague like that, and we feel more comfortable, more stability?
But we have to have other really private calls because everybody's ever done mock trials has gotten closed down.
Yeah, right. Because I know that some guys are doing it, but they're doing it live. They're doing it live. I mean, they're doing it.
Well, we're trying to simplify that, so because we're thinking about coming in just for a hearing, just to say like a show cause hearing for a breach of trust.
Right.
We might not have to, do all this other formalities and things.
Yeah, and I'm still going. I'm still stubborn, dragging them into the equity in bankruptcy, and dragging them in there, reassigning the trustee, reassigning him as my trustee, right? And like you said, before doing any documents, come in there as a grantor. And it's not court yet, but they won't be able to deny you in bankruptcy to come in as a grantor. I don't think so. What do you think?
I don't think they can deny you in any court of chancery.
Okay, right.
The thing about bankruptcy is that you agreed to be under a particular forum of Chapter 11, and you've got problems with that because then you're going to have to reform those onto another law form because you're under the statutes and codes again.
Yes, yeah. Well, you told me that the other day. Yeah. Well, that's something to think about and keep pushing. Okay, Christian. I just wanted to put you on the spot just for a little bit. Okay, thank you.
No problems. I can handle it.
I know you can. That's why I did it. I mean, if you can handle it, God will not give you anything you cannot handle.
It's like, if you have all the necessary elements and one of the methods of formation that the law will recognize that's a trust, according to the law, they have to recognize it.
Right. They have to recognize it, even though they're going to dance around it, but they have to recognize it.
Yes, they have to.
Right. And going back to that case that I was talking about, they went for months. I mean,
what case was that?
Weisman. It was in Arizona this year, and the attorney was threatening the other attorney about losing his license. I mean, big stuff. I went in Pacer. I went through the whole case last night. It took me all night, but I went through the whole case because I want to prepare myself. But I said to myself, everything that a Christian's talking about, it pertains to anything, especially to this. And it took him months. He won, but it took him months. He didn't have to go through all that, and he did not even need an attorney. The attorney did a good job, but the opposing, the pretender lender attorney, I mean, he was fighting back, but he won. The Weisman man, Mr. Weisman, he won.
Could you give us a little more details of what you read so far?
On the case?
Yeah, that particular case.
Yeah, it's this Mr. Weisman. It's in Arizona. The GMAC wanted to take his home, obviously, like all of them, wanted to sell his home, and he got an attorney. The attorney came back and told him from left to right, from top to bottom, why they did not have any standing, and they brought everything from the bank, from the signature, from everything, and he was having a hard time still because the judge was dancing around the case. But this guy came back. He even sold the other attorneys, for the pretender lender attorneys, told him that, saying that maybe they didn't know, but it wasn't wise to keep going on this fraud, what GMAC was doing against this poor guy. I mean, because this fraud, and they were going to be in hot water. Maybe they were going to lose their license. He says it's not worth it. It's all in that case. I'll get you that case number. It's our bank.
So it wasn't about a particular trust case. It was about a fraud.
No, it wasn't a trust case, but it all pertains to the trust. Everything.
Yeah, because everything is really trust, but we don't make a claim for trust, so.
I know.
And until we do, there is no trust.
My point is that he didn't have that this person or the attorney did not have to go through all that BS to win. He did win at the end, but he didn't have to go through hell, and he could have got it over if he knew trust law and the way you're doing it right now. That's what I'm trying to say.
Oh, okay. I thought this was a trust case that.
Well, everything's a trust, but it wasn't a trust. But they preach it.
Unless
they
they're claiming trust, they're not arguing trust, so it's really not a trust case, even though it is a trust case.
Yeah, I know, because they didn't claim to be a trust case.
Yeah, everything has to be trust because there is no money, and a trust had to fill the void, so everything has to be a trust case.
Right. Yeah. And going back to that creditor-debtor, because I know we don't want to talk about that. The secure party creditor, they're a secure party creditor. What do you mean you're a secure party creditor and there's no money? How could you be a secure party creditor? So
yeah, but in their realm, you can't actually argue that there is no money because they say they have money, and in their realm they have money. It's called debt, negotiable debt instruments. That's what they're using as money.
It's going to be an endless story, but anyway.
Yes, and we're trying to argue that there is no lawful money from the private side, and here we are in France trying to argue that we're using dollars, and they're saying, no, we use francs over here.
Right. It's just dancing around the problem. That's what it is.
Yeah, but anyway, so if we know that's the way the rules are, then let's play the game a little bit different in here. But let's go into equity. Let's go into trust. And now I've got the 900-pound gorilla on my side, which is what they had, and they were using him to beat me up with.
Yeah. Like I said, and I feel, I know they're going to dance around it. They're going to play dumb, right? But like you say, they must let you out.
Well, if I stick to my guns that I have a right under a trust, that trustee had an obligation to fulfill according to the indenture, and he didn't, and there's a breach, and here's the evidence for the breach. Here's the evidence that there was a trust. I proved the trust. Now, the court of equity should look at that trustee and say, where's your record of payment or your disbursement?
Right.
You got to produce it right now. If you don't have it with you, you're deemed to be guilty, and I want to know you got 30 days to make the payment, or else you're going to be in contempt.
Right. Now, could we reassign that trustee, the bankruptcy trustee, reassign him as our trustee and have him make the payment? I don't see why not.
Yeah, you could, yeah. Just like we've been talking all along.
It's getting more interesting. It's getting real interesting. I know I'm not ready for that, but I'm excited. The fact that I don't know it, that doesn't mean I won't be able to learn it. Thank you, Christian.
Okay, great. Thanks, Carlos. Okay, next caller. Press *6, *1 to get in line. Anybody wants to ask a question? Eric, you're unmuted.
Hey, Christian.
Hey, Eric.
Very interesting information tonight. Anyways, I can't see anything unless I'm looking through a set of trust eyes now. You've completely ruined me. I have to give you credit for that.
Okay.
And I got an interesting letter, and I saw this today, and I thought to myself, well, how can we apply all this wonderful information to this letter that I got today? And it was a letter letting me know that my servicing for a mortgage that I have is going to be changed. And we'll just see if everybody in the group can pick out the trust terms as I read through this, and then we'll pause for a moment and let them think about it, and then we'll talk about it. It says, we are writing to notify you that the servicing of your home loan, that is, the right to collect payments from you, will be transferred from ABC Bank to BBC Bank on July 1st, 2010. This transfer of servicing of your loan does not affect any term or condition of your mortgage documents other than the terms directly related to the servicing of your loan. Except in limited circumstances, the law requires requires that we send you this notice at least 15 days before the effective date of transfer or at closing. Your new servicer also must send you this notice no later than 15 days after the effective date of transfer or at closing. Now, there's certainly some terms that jumped out at me, and I'm sure that they jumped out at you just now because I saw a method of formation, and I saw a major word that is the one of the elements of formation, and or one of the major elements of what a trust is. And when I was reading that, of course, I thought to myself, well, I never authorized them to do any of this, being that I'm the grantor because it was my signature on the note to begin with. But, of course, I have no opportunity to tell them anything until I claim and prove.
Yeah, because really you have a contract under debtor-creditor that's still in force because you didn't make a claim for trust yet. And that contract is in force.
Right. So, but and of course, we've talked about words or portal terms again and again, words like transfer and right. And, of course, they're using these words in the debtor-creditor world where, of course, we use these words in the trust world. And of course, if I were to claim and prove, then I could stop this action from happening because I was listening to, I think it was from the 1st or the 2nd of this month when you and Chris Summers were talking about, it just flipped, it'll come back in a moment, about the true creditor and who that is. Do you remember that conversation?
Right.
Okay. So. And going back to who the true creditor is, which would be me, obviously, in this context, because I'm the one who granted them the res. So just looking at this as a study, I could certainly put a stop to anything that they're doing as soon as I create the records, which obviously would be a trust receipt, which would be the UCC one that we've talked about so many times before.
Right.
So just an interesting subject for conversation, looking at things through trust eyes, and just thought I might give us a little bit of fat to chew on.
Sounds like they're trying to do a re-securitization or something, maybe because they're signing it to a new servicer. Sounds like some things switched hands in the background there.
Hey, Eric.
Hey, Michael.
Yeah, why don't you just have the first bank pay the second? Oh, and revoke your power of attorney and just have them pay each other.
Michael, you dropped out for about 3 seconds.
Yeah, have the first bank, or, go in there and express the trust, and then have the first bank, you revoke your power of attorney, and have the first bank pay the second bank, and it will dissolve your loan.
Well, realize this is servicing, not, and actually right across the top of the document says notice of servicing, notice of assignment of sale or transfer of servicing rights. So is this actually where, how do we prove that the note passed from one to the other, or is this that they just sold the servicing? So that's really where the question comes in.
Well, they probably kept the note still in trust, but whoever's servicing on it has been switched from the debtor-creditor's contract. But then, like you mentioned earlier, the UCC-1, which was your trust receipt, which would overcome the debtor-creditor relationship because that would be the true proof that it was a trust payment as a trust receipt. But nobody's done a UCC-1 yet. Nobody's created records to otherwise from revoking the general deposit debtor-creditor contracts from the general and redeposit them into special, in effect merging the titles and extinguishing the debt.
Of course, and taking that debt title and applying an asset title and merging, of course.
Yes, right.
And I full well realize that, but what this did was gave me a way to look at things through trust. And then also what I looked at in this was the 15-day notification that they sent out, and that probably comports to some things out of UCC as far as a proper notification, huh?
Yeah, notice, now you've had notice, yeah.
Okay. So if I don't respond and I just let this happen, then of course my silence is my permission.
Well, I don't think you have much say-so over it, because in your contract that you signed originally, probably you put in the stipulations in there which you agreed to at that time of the signing that they can do that, and that's what they're doing. They're giving you the notice per the contract.
Okay.
That general deposit contract needs to be flipped from general to special. It needs to be withdrawn.
I'm with you.
And the withdrawal, redeposit, that'll be the same as the merger, and that's going to be the payment. And then all you need is the registration, which is the UCC form, which becomes your trust receipt, which is a record of the payment. And then you're creating evidence to the contrary or to the otherwise that this is a debtor-creditor relationship, which you haven't done so far. So there is no evidence that you have or no records to prove otherwise that it's debtor-creditor.
Which is also general.
Which is general, yeah.
Right. And when I read this, of course, I thought right back to that 1794 document from the Bank of the United States, and how we have the right to claim the relationship as grantor, because it's based on the grantor's claim and nobody else's. And now going back to that and what Michael said a moment ago about instructing one to pay the other, is that really even an appropriate idea, because it's not the transfer of the res, it's just the transfer of the service?
I don't know. I'd have to think about that. Like, you've got this secondary contract that's really got you obligated to make payments, and that's whether it's paid or not on the one side of the ledger, it has nothing to do with it. It's whether or not your part of the contract is being fulfilled. And until you come back in and revoke the contracts, the original debtor-creditor contracts, for whatever reason, say like a debt validation or something to give me some kind of authority to revoke the signatures or some kind of fraud or something going on, well, I got to get them out of play first. Then I can come back and get all the special deposits that are done under trust, and then I could apply those payments or the actual deposit as a payment or an extinguishment of the debt.
And then if we were to do that, now would it be a better strategy to wait for them to not make the payment, wait for them to take action against us, then make the claim, and then if they continue to make, then at that point would it be a false claim since we're the only true creditors, in order to kind of draw them into the web?
Well, if you have the ability to continue to make your payments, I'd suggest continue making your payments up to the point to where you're going to say, now this debtor-creditor thing stops, and then you're going to have to stop making the payments because you're switching the nature of the whole affair from general to special. You're switching it to trust. So you can't continue on by your actions to support the debtor-creditor relation that's going on. So you gotta draw the line right there.
Now, here's another interesting thing with the same property. I have a homeowners association that, of course, wants money every month. And if they were to file this pendants, that would be a debt title. And, of course, I could create a trust receipt and pay it. And then the court has the power of conversion to convert my res into FRNs at that point, correct?
The court, well, are you going to give them the authority to do that, or what?
I create a trust receipt, which would be the asset title, go into Chambers and do the merger.
Oh, you're going to
take
the
from
debt.
that.
Let's see, the association. Huh? Yeah, you're going to take the debt from the association and merge it. Okay.
Now, would the court have the power to do the conversion and then issue the association a check is the question.
Yeah, I think the court has closer ties with Treasury.
Okay. Well, I have another person who's behind on her fees to the tune of about $10,000, and she's got a list pendants from them as well. So I have a great opportunity to apply this, where I'm actually current on this.
I would suggest that she put her, if they did a less pendants down here in Florida, but that's before the less pendants. I would suggest if anybody's falling down on payments, that they put it into a trust, at least for asset protection. Because if you don't
own
a
land trust,
yes, if you don't own the property, then how can they take it?
Then they got to find the party who's actually got the interest in it.
Yes, right, and that's private.
That's right.
And they may just let you go because now they'll come after you for the payments, but now they have no collateral to back it up because now the payments become due, maybe from acceleration clause, and so conditions precedent's been fulfilled, but then the whole thing becomes due, but then they'll, at least they don't have the security. The security is no longer in play.
Right. All they can do is lien up your title. Right.
That may buy you some time to come in, and plus they don't have any more bargaining power then too. So.
Right, and then if they were to lien up your title, let them go ahead and create the debt title, and then you bring an asset title and merge it and then terminate it in order of dispersion.
Yeah, the same NTT, merging the titles, pay the debt, yeah.
Right. I mean, it's consistent all the way through, and I'm just looking at it from the frame of if a bank brings an action, or if a homeowners association or any of them, if the judge has the ability to do the conversion, it doesn't matter who brings the claim.
Right. But I think we need to start thinking maybe some asset protection devices of the trust being that, and start getting our assets in it.
I'm glad you brought that up. So I'm gonna suggest for you to go ahead and lead on that. Have you gleaned anything out of Corp CJS on that frame?
For asset protection on trust?
Right.
Nothing has jumped out so far as particular that. I've been geared in more towards offense than defense. But that's probably where we should be going to start off with. We should be putting on our assets in a trust, just so they're in trust.
That's where they need to be from the beginning anyway, because of course that's the frame we all want to be in. Yeah,
or start operating in the trusts that are already in place, because everything is all obviously in trust, and we need to get it switched around so that it's to our liking instead of granting it to their liking.
So maybe we can start looking for some nuggets or some things to start talking about in that realm, so we can alert, because the application of using trust offensively is, even though we've been talking about it for months, it's still foreign in terms of application compared to utilizing trust for asset protection, with so many people are familiar with for so long. At least if we started doing that, then we'd still get some working knowledge of trust beyond just talking about it until we get stung somehow and then being forced to apply it. That might be a good approach.
Right. Like something is going to happen in the near future. You know, it's coming down the pike, rather than nothing, at least put it in trust. It's like what we're trying to do is develop a model from start to finish, from A to Z, from creation to enforcement, So at least we've got a good model and understanding of what we know is going on. And we don't have to have done it, but just so that we got some way, a plan. Because you just don't jump off the edge of the cliff without knowing what's down below.
That's exactly what it feels like when you get presented with a debt title.
Yes.
If you'd like to ask a question, please press 1 to add. Your request has been received.
It looks like it's everything coverable that we could cover that comes to mind, not taking into account anything unforeseen. But at least we got it down to where now we can start acting on it. Because we got a plan from A to Z, from start to finish. At least some kind of guideline to go by.
Now, speaking of models, I was talking to a paralegal earlier tonight, and of course she's all on the at-law public side. But I talked to her about if she'd be interested in working with me on doing some pleadings, and she said yes. And I said, so do you write a lot of pleadings? And her response was, well, we actually have a program, because most of the pleadings are the same, because most of our cases are the same type of model, and we just basically change the names and the amounts, and that's what we put in there. And perhaps we could come up with a set of document models with a similar idea and approach to try to come up with as many different things as possible, so we can have a working library of things. And maybe whoever's on the call that's listening, they might want to think about doing that, and then we could work together. And even some of the new people, look at pleadings and look at cases out there and just how they're constructed, just to get an idea of what you might be looking at, to have some reference for what pleadings look like. Because, of course, from a few weeks ago, we're going to express through our pleadings that we want to invoke equity, and maybe we could even find some pleadings somewhere somehow that does that, to have a model to discuss even.
Yeah, well, I've been looking. I haven't seen any yet, so.
Okay. Let's talk about maybe what kind of cases, to maybe get all the research gears rolling. Mike, what kind of cases might invoke equity that might be familiar with on the at-law side? And of course, we know it's not, because of course we've discussed that there's at-law in the public and then there's at-law in the private. But even in the equity that's in the public, would those pleadings, based on what CGS said, still have to invoke equity within the pleadings, even in the public?
Yes.
Okay. Then in the public, and if you could remind us that equity that's talked about in the public, give us a better reference maybe to find out what kind of cases we might want to look for. Because I know you and I have talked about that before, but there's a lot to go over. It's hard for me to retain it all.
That's why we're going through the equity book in CJS, because equity is the primary enforcement, and if we can't go into court of equity without knowing how the court of equity operates.
Right, but you've also talked before about how they merged equity with something else in the outlaw side.
Yeah, they put it all as one form. It's accessible through one court. But really, they've stuck pre-33 equity in chambers and come up with a statutory equivalent, which is nothing more than statutes and codes, public. And an example of that would be the unclean hands doctrine, which is on the public side, but then that comports to that he who comes into equity must be doing equity. There's the maxim. That's equity, where the doctrine was not. It's statutory.
So what we're talking about is a maxim in the statutory.
Yeah, we want to talk maxims instead of statutes and codes.
But isn't a maxim in statutory kind of it's kind of like saying apples and oranges?
Maxim and statutory?
Yeah.
Well, if it's this invisible realm that got turned on and we're now in equity, and it got turned on by talking about just the maxims, and as long as you don't put anything statutory in it, then it can't be statutory.
Even if it's in the at law in the public.
Right.
Okay.
I just don't want to make. I want to make sure that I just don't put my SOIs into the public, because the notice definitely goes into the public, but the notice can contain the equitable invocation. That's the NOI that's in the public court, but the SOIs, which is the material facts to support the equity, is going to be in chambers. Because I can put the notices in there because those are public notices. But they don't tell much, because if you want to know the details, that's going to have to be in chambers. So I'm going to do my colorable pleading with my maxims, claiming pleading special matters, and I'm going to do it as a counterclaim. I'm going to put a summons in there, and I'm going to subpoena the trustee.
Who has a duty?
Yes.
Because you have a right.
Mm-hmm. So this is not that hard. And as we went over on those 2 or 3 Saturday calls on the equity, how to get into court of equity, we're coming from an at-law basis brainwashing, and we're not realizing how simple it is in equity. So,
is it really appropriate to express that right in the public, though? Or is that just too much truth?
We're on new ground here. Who knows how much truth you can bring in there? You don't want to make it. You don't put your substantive rights in there, which is going to be your material facts to support your NOI. Where that exact line is, it's going to be keep it as colorable as it can be, but yet, just to invoke the court.
So this is the path where we're all carving to really determine what that is.
Yeah, we're taking a path that nobody's gone on before. We're taking a total trust outlook, we're taking a total equity outlook, and we're doing something 180 degrees from the debtor-creditor path. And all this is basically new ground. And some of this stuff is going to be some trial and error, and maybe we might have to learn the hard way on some of this stuff, but, and then it may be as easy as 1, 2, 3. Who knows? Because it's totally different. It's flip-flop. That's why it's jumping ahead, because I realize people got problems, and they're looking for anything at all to throw in that might work. But that's not the way to go about doing it, because I don't know of any shaky tool holders. I don't know of any shaky tools. I know of only shaky tool holders.
What a great metaphor. And I can speak from experience of literally shaking with the tools in my own dealings.
Yeah, it only takes 20 seconds for somebody who knows whether or not you don't know. And then you're dog meat.
Yeah, 'cause as soon as they see you shake or step off, they're going to know.
We're only going to be as strong as our weakest link. And if the person goes into the court and has to speak the motion, and they can't speak the motion, the judge's going to know in 10 seconds. I'm afraid we're all going to have to be attorneys if we're going to go into any kind of court. You know, that's just the way it is.
Well, based on
That's where we should have been all along. We should have been living at law all the time, in the lake, in law. We should be all the time. Nobody knows one iota about law.
Well, the real challenge with that is there's plenty of attorneys that are completely impotent and do nothing for it and take people's money.
Yeah, well, I'm capable of getting into my own jail without an attorney, let alone being escorted into jail by an attorney.
And taking your money.
Yeah, and all of my rights.
And all your rights, right? Yeah, because he represents you, and you become an incompetent, his incompetent client. Yeah, because of course when you hire one, you claim yourself as incompetent.
Yes.
While you're on a mission. So, going back to the document that I was reading, as far as maybe some of the terms, hopefully everybody picked up on. It was the word transfer as far as trust formation. I hope you all are listening or were listening. And when I saw that, I thought to myself, these people are, I was wondering, are they asking me to grant to them with the word transfer, and by them sending me this letter without directing the transfer, by me just being quiet and accepting, then I accept them transferring the res through my, I guess by accommodation by my signature.
Yeah, they get you on a redraft problem.
Okay.
We've got a few other callers online, so why don't we get to some of them?
All right. Thanks so much, Christian, and I'll be listening.
All right. Thanks, Eric.
Yes, sir.
Okay, next caller. You're unmuted. Carlos, you're back.
Yes, thank you. Yeah, I just want to make a quick comment on the land trust you were talking about if they try to put a lien, they cannot put a lien on that property because it doesn't belong to you. I went through that BS already, and I called the lady. I says, she says I owe them $2,500, right? $2,500 change. And it says, yeah, but the property doesn't belong to me anymore. I said, well, there's a lien or there's no lien. It's under a trust. It's under total different ownership.
Right.
That's it. They cannot put a lien on what's not yours. You owe it, not the trust. Who knows who the trust belongs to? It could belong to Obama. By the way, Obama has his properties in land trust, in case you didn't know. I found that out. Yes, honestly. I know it's funny.
Most of the people in the know have their properties in trust. I wonder why. Because
all the big shots, they did everything under trust. They control. They don't own. They control it, right?
Right.
I mean, which is smart. And I keep telling everybody, you have to own. You should not own anything. I went through this a long time ago. I'll make it real quick because I know you have another guy. I went through this. Someone had an accident. He had a DUI. And he told me, could we do something? And I says, I doubt it because this guy owns like 27 properties. This guy taught me how to do investing. And he says, I doubt it. It was New Year's Eve. He had an accident. And to make a long story short, they ended up suing him. But I told him, tell him that you're going to sell your property. Obviously, he's not going to tell him he has 27 properties. Tell him that you're going to sell your property. As soon as you sell them, you're going to pay for everything. I just wanted to buy some time. I did every single property in every single trust. One land trust for one property. You you don't put 2 properties or 3 properties in one land trust, because if you lose one land trust, you lose all the properties inside there, right? Obviously.
Mm-hmm.
So I did 1 for each. And at the end, he lost something that his brother could not quit claim to a trust, convey to a trust, because his brother was in Mexico. That's the only property he lost, in a vacant lot in Palmdale. The only property that he lost. The other ones, nobody knew. Nobody found out he owed them. So I think that's a victory. Instead of losing 27 properties, losing 1, come on. See my point? You see my point? That's I keep saying, and I keep telling everybody. And I'm glad you brought it up, because anybody who has, even if you don't own a property, you should know how to do this, because you know somebody that, hey, if you don't do it, they're going to lose it. Trust me. Trust me. I went through this. I mean, I said, I'll do it. It took me about 6 to 8 months, and I knew how to do it, and I had the progress. I had everything. I was just lazy. I procrastinated. And I said, you know what? I better start doing it before I'm sorry, and I did it. So it's a good point you brought up. Thank you, Christian.
Okay. Next caller, you're unmuted. Jacob.
Hello.
Hey, Jacob. Do you have an NTT question?
Oh, hi. How you doing?
All right.
Of course.
All right.
How many do you want?
All right.
On this land trust that is being discussed, what would be the effect if you backdated it to the date that you signed the escrow papers?
I'm not in favor of backdating anything, you know. I'm not in favor of that. We got some echo back in the background.
That would have been your original intent and purpose. Huh? But it would really be your intent. Why not?
Like my intent, yes, but I wouldn't backdate things and sign things backdating them. Although my intent would be that it took place, the creation back when I.
No. You sign it in the current time, like you sign it in the current date. But the actual deed you had made up way back when, and you just had never recorded it.
Yeah. Okay. Yeah. Because I want to keep it private. Yeah.
Yeah. So, but what would be the effect of putting the date that was your original intent and purpose?
Put that date back when it was in some kind of documentation?
Yeah, just you made up a grant deed on that date, same date as they inadvertently put the so-called deed of trust into the county, and on that date you also made up your own original. You had a grant deed that was your own intent and purpose, and that just now you're recording it now.
Yeah, that's when I did it. Yeah.
I mean, couldn't that be my intent and purpose, Christian? My intent and purpose was to actually do that the day I went into the deal, and so at some point between then and now, I had made up a grant deed and held it in the private, and now I want to bring it into the public, so I'm going to.
Yeah, but I think that's the whole purpose of a private trust, not to really bring it into the public because you don't want the public to know. So.
Well, I mean, the grant deed is just bringing it in, the bare minimums. You're not bringing the actual trust itself. You're just bringing the grant deed that's conveying.
Anything wasn't a beneficiary sign. But yeah, it would probably have to be recorded.
I'm just wondering what the effect is. I mean, when you file a grant deed in the county, aren't you creating a trust with the county?
Yeah, you got to trust you're creating. Yeah. I don't know how the deed. What's on the deed?
And there's
how it's worded.
On the trust deed.
Yeah.
The warranty deed or the deed of trust, you're saying.
Yeah.
Okay. So if I'm gonna well, I don't know what they do in Florida, but, you know, in a non-judicial state, they're going to give you a grant deed as your thank you receipt, so to speak. And so now the date of that grant deed that they're giving you as a thank you receipt versus if you're going to express your intent and purpose as a grant deed, and if there's a difference in the two dates, let's say the grant deed that you give them is the actual date of your expression of your real true intent and purpose, and it's on the date of the signing of the documents that you're going to, which would comport with the date that the title company, acting as a so-called trustee for the beneficiary/bank alleged lender, then if your grant deed precedes the deed of trust that the county issued, wouldn't it have the superior claim position?
No, maybe in the common law realm, maybe so, because we're going to say by intent, but on the public realm, they go by manifested records. And the priority establishment is when the time of the recording, and that's what they're going to go by.
So would you want to be before or after the grant deed that they churn out?
Well, if you want to have it some other date earlier and you say that, well, I never got around to recording it, you better have some kind of second witness sign on your document that's going to back you up because you're going to need it. Otherwise, all you did was make an assumption and you backdated it and it doesn't count. They're going to go by the actual record.
Well, you're going to have a second witness because you're going to have a trustee, and you're going to have to put in a certificate of trust.
Witness to prove
so you're going to have to put in both documents.
Because you're going to need a witness to establish the fact. So yeah, if you recorded your say 2 years later after you did the trust, but at the time that you did the trust, you better have actual dates and witnesses to prove that.
What, that you put together your grant deed, your intent and purpose?
Yes. Yes. You're going to have some witnesses to the fact that they're going to test, yeah, we did this 2 years ago, and that's going to establish the prior.
Well, first you said witness, and then you pluralized it and said witnesses. So one witness is okay?
It takes two witnesses to establish a fact. I can be one and then one other.
Yeah, okay, I got it. I see. That's fine. Have you ever given that thought at all, Christian, what I'm trying to derive at?
Yeah, many people have tried doing backdating things like that, and they ended up getting caught at it. So, you know, you got to make sure you got to have...
What's there to get caught at?
You come in with just an NOI claim.
What's there to get caught at?
An NOI claim is unsubstantiated without some kind of material fact witness, and that would be the SOIs. And you got to have two witnesses to back up a claim, an NOI. Otherwise, it times out.
Okay.
We don't know how to do basic government.
Okay.
I can't just make a claim.
So when they okay, so when they do the escrow, when they do an escrow and they put in the deed into the county, and then the county, is it typically state by state that they do the grant deed the same day as they receive the trust deed?
I don't know. You'd have to look on the dates on when things were recorded. I imagine they're going to be within a couple days of one another, if not the same day. I think you're.
So if they were a couple days from another, if you put, so if they were a couple days from each other, then you want to put the grant deed. If they were a couple days apart and you put your grant deed in before they issued a grant deed, what gives them the right to issue a grant deed?
You gave them authority to do it.
So you could withdraw that journal deposit, so that yours would be the special deposit.
Yeah, you can.
Is that accurate? Okay. Okay. Thanks a lot, Christian.
All right.
Thank you.
Okay, Terry.
Unmuted. Muted. Unmuted.
Terry, you're unmuted. Terry, you're unmuted. Okay, next caller. Three 353, you're unmuted.
Muted.
Hi, Christian. Dominic, how you doing?
Hey, Dominic. How are you, Ken?
I'm good.
You sure?
Just a couple of small... Sorry?
Are you sure?
Yeah. I'm just a bit tired, but I'm okay, yeah.
Right.
Just a couple of small bits here. You spoke about maxims of equity earlier on, and you spoke about it in a few previous calls as well. I was just wondering, would it be pertinent to state a maxim in any of your paperwork?
Yeah, there's one equity maxim that we definitely said had to be in there.
Okay. Is that the clean hands one? Or that's more of a doctrine, you said?
No, not the clean hands one. No. Dear, I don't know where it's at exactly off the top. I have to look for it now.
Oh no, that's cool. I'll probably get it on another call. It's okay. But you think it would be pertinent anyway to put it on? And I'm talking about putting it on my equity counterclaim endorsement section.
Yeah, I think that equity maxim said basically if you're invoking equity, that has to be heard in equity. So it was kind of like the equitable one that you put in there that invokes equity. You know, we went over it on that Saturday show on that how to get them, but I forget what the maxim was exactly.
Okay, that's cool. Oh, no, that's fine. I'll find it. I know the two calls you're talking about. The other one was regarding the in-camera hearing. When you're going in as plaintiff, obviously, and you're requesting the judge to schedule an in-camera hearing, only the parties to the private trust can only be present in the in-camera hearing. Am I correct?
Well, you could put a protective order on there, and only the judge's eyes only could be in there. You know, if you could get that through. But yeah, normally it's going to be only the parties involved.
Okay, I'm just reading here just in our own law dictionary, and it's obviously talked about from an at-law perspective, but just as where a case is heard in camera, the public must be excluded. The only persons permitted to be present are the parties directly concerned, their legal representatives and officers of the court.
The officers of the court are probably present, but they probably can't speak because they're the public side, and they can't speak because the court of equity can't hear them.
Okay, that's fine.
I think that's what's going to happen.
And the legal representative, obviously, they won't be able to attend a private hearing. And you're saying if you get in a protective order, obviously that will shut them out automatically.
Let's put it this way: if there's anything at law said, it's got to be totally ignored.
Yes, yeah, that makes perfect sense. Yeah. The only cases, according to the laws here, that would justify an in-camera hearing would be an urgent application for relief by way of injunction, or cases involving the disclosure of secret manufacturing processes. Now, private trust technology isn't exactly secret information, but it's not fit for the public, so you term it as just confidential, would you? Just confidential information. Would that be strong enough to get an in-camera hearing?
Yeah, we were coming in with CCI information or trade secret, but I think that's too public. I think what we need to do is stick with just confidential.
Confidential, okay. And I think Carlos was bouncing a few things off you as well, and I think he might have asked you what gives you the right to request an in-camera hearing, and I think you just responded there because you have confidential information. That was your right. That's pretty much it. I just wanted to just ask you those two small things. I'll find that maxim on one of the calls, and I'll place it into the paperwork. And that's pretty much it, Christian. That's it. That's me done.
Okay.
All right. Thank you.
Carlos, you're unmuted.
Yeah, thank you, Christian. May I answer Jacob's question?
Yeah, go ahead.
Well, this is the way you do it. I'm not telling anybody to do it, right? The way to do it. See, let's pretend you give me your house and says, you know what, Carlos, take over. Like many people have done it. I'm gonna wait. It's yours. Do whatever you want. I have the right. If I backdate my land trust a year from now, I always backdate it, and then I add a certificate of trust. Only I know, and only I swear to myself that that trust has never been tampered with. And there it is. Because if you try to get a grant deed from dated from a year from now, it has to be notarized.
Yeah.
So it doesn't fly. It doesn't fly. They won't believe you. Why make things so difficult? Write your agreement, date it, like the one I did, the Falcon Crest Drive Trust, the Falcon Crest Drive Trust, dated April 3rd, 1988. And I add to it a certificate of trust. I certified that trust hasn't been separate. And it hasn't because it's been under my possession. Who knows and who cares? That's it. You don't have to make things more comfortable. And I've been doing this for a long time, and it flies all the time. If it's right or wrong, who cares? It works.
This before the mortgage came into existence?
Can you say that again, please?
Would it be before the mortgage came into existence, say? Or no, I guess you couldn't do that either. Oh.
No. See, he wants to claim a trust, a land trust. A trust is a trust is a trust. We know that. He wants to claim a land trust on a property. You can do it. It doesn't care what mortgage is it on. It doesn't matter whether he has a mortgage or not. You're just claiming that that property belongs to the trust. Who's the beneficiary? Who cares and who knows? Only the trustee know, and they have to compel him in court in order for him to reveal the identity of the beneficiary. You can date it as far as you want, and you're going to add to it a certificate of trust, you saying that under penalty of perjury, you state that that trust hasn't been tampered with. And it hasn't been tampered with because it's been in your possession. It's been in your mind all the time. Now you're just expressing it in paper.
If you'd like to remove yourself from the queue, please press 1. Otherwise, press 2.
Less penance action.
Well, yeah, and you're going to bring it up. You can do it before. You can do it. Let's pretend they're coming in with a less pending action and they want to take the possession of the property for whatever reason. You bring up a trust that you bring under your mattress. You never record it, But you're going to add a certificate of trust that whatever it's in that trust indenture is true according to your best knowledge. It hasn't been tampered with, and you sign it. So you're committing to yourself that you haven't tampered with it, nobody has tampered with it, and you're showing it to the public. It works for me, Christian, and there's nothing illegal about it. You just backdated it to your trust. You just forgot to express it. Now I'm expressing my land trust. It's been in my mind. I never got to it and put it in writing. Now I'm putting it in writing that I had this trust in mind since 5 years ago. And I'm going to certify that that's true in writing. And you go ahead and certify it, and you go ahead and notarize it, and the county will buy it. I've done it more than 3, 4, 5 times. They are recorded in the county records. I think I sent you one of those copies. They are recorded right now. They buy it. They'll ask you, they want a certificate of trust or they want the trust agreement. Well, it's a lot easier for me to do a certificate of trust. 1 page, one notary. That's it. You just telling them, you just saying yes under penalty of perjury, and that trust hasn't been tampered with because it's your own trust. It's been in your mind, and it's yours. I mean, I don't see anything wrong with it. I do it all the time. But did you get my point?
Yeah.
You can date it as far as you want, as long as you put a certificate of trust on top of it. Here, this is my grand deed. This is my trust. I'm bringing it up right now. It's been on some other's name before. That doesn't mean it's not in a trust. Here it is, and this is proof, and I certify that this all under penalty of perjury. It's true. That's my certification.
Make a caveat there that you can't go back past the time that you didn't own the property.
Can you repeat that again, please?
If we had a mortgage closing, say 2 years ago, I couldn't go past into, say, 2 years or longer back.
You can.
I didn't own the property.
Well, that's you went through that in Florida, right? Or is that an example only, or what?
No, I'm saying that I wouldn't want to make it so far back that it was before the time of the acquisition of the property.
Right. Yeah, we have to make it realistic.
Yeah.
But bear in mind that I'm always. Sorry, go ahead.
You know, some people will say, well, we can make it any time because we'll make it for 5 years ago, but then we didn't acquire the property except for 2 years ago.
Yeah, we have to make things realistic, obviously, right?
Yeah.
Like, let's say on my property, on my home, I change ownership every so often. And on a property that I'm defending for someone else, I'm trying. Well, I should not say defending. I'm trying to help somebody else. I conveyed his property into a trust, and I backdated a year from now. He had the property for about 5 years. I made the trust, and the trust agreement, and the certificate of trust, saying that this trust was born a year from now, 2 years from now, and that's fine. And then I can add into that trust agreement whatever I want in it. I can add 1% of my beneficial interest or 100%. Right. The point is that if you do it that way, you can shift the ownership into a trust, and now they won't be able to get access to it because they have to foreclose on the owner who owns that note. One of the requirements in California, that property has to be in your name. If you got the loan in your name, your note in your name, they cannot foreclose if the property is not in your name. They have to foreclose.
We need to examine the titles here because of what's really happening. They may be going under the assumption that the title, the legal title, is being followed by the mortgage. But when you come in with your land trust, you're splitting the titles because now the the legal title is now in the hands of somebody else, and somebody else has the mortgage.
Not only that, it becomes personal property, not real property. When you put it in, place it in a land trust, it becomes personal property. It cannot be partitioned.
Okay.
It cannot. I went through this through, I don't know if I told you this, my brother went through hell. He's real sick. They wanted to sell our property. He owns 50% of it, and I own 50% of it. He owes the government because he didn't have insurance, health insurance. He owes a lot of money, more than $500,000. They wanted to take his property. But since I had it in a trust, I explained him that this property belongs to a trust. I'm the beneficiary, and by law, I don't have to partition this. See, I don't have to sell it and give him my brother's half. That's my point. They respected that. So it's something to take in consideration instead of just leaving your home, your property, just in the open.
Yeah, right. But I think if we think titles, you know, the trust splits the perfect title into two. You got the equitable title or the beneficial, and then you got the legal title. That those two titles, they can be moved around.
Yes. That's the point. We can change ownership. We can change ownership in 2 minutes, and all you have to do is bring the document out of your mattress and assign it, and you can notarize. And by law, you don't even have to notarize your agreement that you have at home, but it's a good idea to notarize it every time. What I do, this is what I do. One of my tricks, I always do 3 of them. My wife is the beneficiary, my son is the beneficiary, and I'm the beneficiary. So whoever gets in trouble, we destroy that. He doesn't own anything.
Mm-hmm.
See my point?
Right.
Okay, Christian. Thank you.
Okay, thanks, Carlos. Hey, Terry.
Hey, Christian, this is Terry. I have a question related to what we're talking about here with the Inter Vivos Trust. Looking back in Gilbert's, under the methods of trust creation in section 262, where it talks about Inter Vivos Trust, it says if the transfer is made by the owner during her lifetime, the trust is an Inter Vivos or living trust. Such trust may be 1, revocable in whole or in part, or 2, irrevocable, and including where the settlor retains a limited power to amend. Now, my question is, if we set up a land trust like Carlos is talking about into an Inter Vivos, transferring property into an Inter Vivos trust, what would you recommend that being, revocable or irrevocable?
Well, actually, they said in the book there, didn't they say that it was irrevocable, but there was a power of attorney for, what was it again, they said?
It says irrevocable, including where the settlor retains a limited power to amend.
Change things around.
Okay, and what would the definition of that or limit of that power
around
be?
Without terminating the trust thing.
So anything with the exception of that should be fair game. Okay. And that way, if it's irrevocable, that would prevent a judge from coming in and making orders if it should ever be pierced in court. Yeah. And because it's not a statutory trust, it's a private or pure trust, then the odds of anybody finding out who the trustee is to make even such an order under their own discretion would be not a concern.
Somehow they come against the property somehow, and they want to know, then you'd have to come up and say, well, this is in trust, and then who's going to be making the claim that's in trust?
Yeah, it'd be much like Carlos is doing, saying, I don't own the property anymore, it belongs to a trust. And they would query you as far as who the trustees are, and of course you wouldn't reveal that to him.
He doesn't own the property anymore that's in trust, so.
And you could have a private agreement that you being the seller of the property to a trust is not authorized under penalty of fine to reveal who any parties to the trust are. And with the grant deed in the county,
yeah, but I think
that's all they can find out is the name of the trust.
The titles again. We have to look at the titles. What happened? What was transferred with the titles? The equitable title went one direction. The beneficial title went another direction. They're looking at it as being the legal title and an obligation, the security agreement, are following each other. But then if this went into a trust, it separated the titles. They went someplace in two different directions. Yeah, I think you should look at it that way because you separated the security agreement from the equitable title because now there's a new owner. The security agreement can't follow that new owner, which the legal title got switched to this new owner.
Yeah, and the beneficial title remains
now
with
they
the
can't
mortgage
foreclose.
holder.
That's your issue.
Cool. So that's where the separating the titles
the trust
would
that
be to our
separated the titles,
benefit.
and some other new owner has it. The legal title, the trustee, the new trustee. But it's not the fact that I can reveal who the new trustee is. No, they can't foreclose even if they knew who the new trustee was because the security agreement on the old was separated from that and the title was moved.
So if the mortgage company wants to foreclose on it, they're going to have to merge the titles to the new trust or the trust that owns it in order to even
how are they going to do that?
Foreclose.
Right.
They can't.
Mm-hmm.
They're in a catch-22 then. Okay, great. That helps me understand.
Someone would compare that in relation,
to
the beneficial interest. Who's holding that title in? It's all about titles. Who's holding what title? And we're talking about one title. No, we're not talking about one title. There's two titles.
Yeah.
Mm-hmm.
That 9/10 title and 1/10 title.
All right.
Okay. Thanks, Christian.
Christian?
Keep up the great work.
Good evening to you.
Hi, Chris.
I went ahead and did the paperwork, and I'm impressed, the paperwork that Carlos was talking about, and I even bumped it even a little bit more than just that. I gave notice today to the county recorder's office and to the sheriff's department and to the president of the board of supervisors, informing them that I have reverted the trust and the property back into rural route, of which I went ahead and named the rural route under Rural Route 1, which puts it back under the Republican private, and I went ahead and chose a number along with what used to be the name of this area, which was Walnut Grove Park. And then, therefore, I took the Spanish land patent and made that as being the avenue, which was Rancho de Novato. And so what I did is I actually did kind of an easement with my papers, of which will identify the land trust and so with the land patent that has already been privately filed on a UCC that shows that it does exist, and I gave like the notice of intent to preserve an interest document with the UCC file numbers that supports that they do exist. Therefore, the notification I did today was just basically changing the address, of which I went down to the post office and went ahead and told them to stop delivering mail to the property. So, to the most part, I feel like what I started 6 months ago by setting up this trust has finally came to a full completion. And I feel really good about it, and taking it one step further out of the commercial description by not naming the property through the commercial retail address nor the APN number, of which is their identifications commercially. I did not mention the property other than meets and bounds and by easements to the county, to the state, to the United States, and I added that language in it instead of using any kind of a commercial value.
When did the land trust come into existence?
This particular one, the land trust was created today. Today was the start point.
Okay,
the land patent was done on January the 26th of this year.
All right, the land patent was on earlier?
Yeah, land patent was done 6 months ago.
And then the trust was formed after that?
Yes. The trust was formed, or it was completed, and notification went out. The rural route, new ID was given, and the revocation and the cancellation of the commercial retail value that they described the property is no longer. I gave notice today that it's no longer acceptable. Therefore, they were given notification that they are not to trespass for any reason at all, and that at some point I will be making contact with the assessor's office in order to complete the provisions of taxation, of which I'm going to have to learn a little more. I think maybe Carlos, if he's on the line, I'm going to have to talk to you about that, Carlos. But I want to do a presentation with merging the titles with them, and so therefore I wanted to complete my land trust and the land patent. Now everything's done. Now I can go ahead and do some kind of a submission of merging the titles and completely exempt myself for the rest of my life out from underneath the commercial value that the government places on property.
Yeah, watch the separation of titles and bringing the titles back together and separation of the titles again, you know, and watch where those titles go.
Okay.
Keep them in track in your mind, you know, what you're doing, because you don't want to breach any of the trusts or terminate some of the trusts, you know, out of sequence and things.
Yeah, that's why I kind of played it out. You know, I'm a little bit like you. It takes me a little bit of time to really start having certain things sink in, but once I finally actually have an understanding about a certain subject matter, then I actually live it. I mean, it's actually a part of my life. So it's like being assimilated. The information that is being taught through, you know, NTT here, I'm actually starting to live it, and my whole thinking and everything I do is just that. It's all about trust, and every act that I do now is how to figure out how things are going to fit together and how to utilize it to its best, most efficient way. So I wanted to say thank you one more time, because I am absolutely thrilled with what it is that we're learning over here. And tomorrow on our special call, I have some interesting conclusions that I found this last weekend, of which I wanted to run it past you before we put it out on the public forum. But I shared it with a couple of the boys in the group already, and I'm sure that they probably already shared it with you. But tomorrow, when we have our teachers group, I'd like to share this stuff with you that I came up with. And I think it's going to be very impressive, and it's a big answer. It just dawned on me last Thursday when I was working on bankruptcy stuff, and it just like, whoa. It just hit me like, whoa. I was so impressed when I stumbled across that, but I'll share that with you tomorrow, and then if you want, we can share that on tomorrow night's call if you deem that that's something you want to share right now. So I'll wait until then. But that's pretty much it for what I wanted to say. I was going to go back and I'll talk to you about it tomorrow. But yeah, that's pretty much it. I'll let you talk to somebody else. Thanks.
Okay, Chris, thanks. Appreciate it. Patrice, you're unmuted.
Hi, Christian. This is Patrice. Just wanted to, I realized I need to get under a trust ambassador. I don't think I ever formally did that, so I just wanted to know if I could just put out my information, my contact information. My Skype name is Catrice, spelled Catrise, C-A-T-R-I-S-E. And my email address is catrice@gmail.com. Just wanted to
Could you give her Skype
get
again?
out there. My Skype, Catrice, C-A-T-R-I-S-E.
If there's any trust ambassador heads out there, would maybe give her a Skype call or email?
Yeah, I'd really appreciate it. That's all I wanted.
Okay, all right. Well, thank you.
All right, thanks a lot.
Unknown, you're unmuted.
Hey, Kristen.
Albert, how are you?
Fine, man. Man, what a nice call. Along those lines, I've got a few issues, and one is this. When a party wants to get rid of the state contract that they both got into, in the past, there's the statutory law that says, especially here in Texas, that says that they have to wait 60 days, even though they're not contesting it. Does that apply to those kinds of folk?
I think if they're going under a statute and code remedy, then they're going to have to go by what the statute and code says.
Okay. All right. And another thing I wanted to tell you is that I myself had an issue last week that I went to protest house taxes. And I let them, present their presentment and everything, and after all said and done, I went ahead and claimed the trust, and I made them all co-trustees. And let me tell you something. The head guy, there's always a guy that is in charge. He kept getting up and going to the lawyers every time I opened my mouth, so it was a very long meeting. I don't know what was asked, but I do know that he didn't understand a thing I said. But they wanted me to sign documents, and I said, no, I ain't going to contract with you people. Then initials, I'm not going to contract with you again. And, that's the way it went. I don't know how many people on the call might protest their taxes going up, but I do it all the time. But this is the first time I've ever been able to go down there with a little bit of heat. Never had heat before.
Yeah,
anyway, I just thought
I'd grant that.
Go ahead.
I would tell them
Go ahead,
I don't grant that.
You don't what?
I could say I don't grant that.
What do you mean you don't grant it?
Well, whatever they're saying, if I don't want to agree to it, I'm not going to tell them I don't agree to it. I'd say I don't grant that.
I see. I know it's not over. These people still ignore you, but at the meeting,
come in as grantor in fact, and then you can say, no, I don't grant that.
Okay. Well, the meeting's over. Now, I think they're going to send you a document where they made a determination as to the taxes, and they did lower it, by the way. That's a first for me. They've never lowered it. So anyway, they lowered it, not much, but, it's like, once you get your foot in the door, then you push the door open. But, I'm slowly starting to use the new NTT, and I find it successful up to the point of my education. And I wanted to say that to you and people on the call that when you start walking the talk, you'd be surprised. You'd be very surprised. And the more you learn, the wider the door opens.
Yeah, he who sleeps with rights has no rights. And equity, there's where all the rights are. So we need to learn how to operate under NTT because that's an equity.
Now
I got all the rights.
Yeah, you're right. And tonight's call was real good. I'm glad Carlos brought out that information. It's just encouraging to hear it. The next issue was this. When you decide, a person decides to claim the trust, now I know that oral is one of the methods, but once you do that, do you still have to have, like for instance, if you already own your property, you bought it out already, do you still need to get those signatures when you made a declaration?
Of the property?
Right. When you're going to be stating that there's a trust here and it's a private trust, you still need the two signatures, correct?
Yeah, everything's got to be substantiated by two witnesses to prove a claim. So whatever it is you claim has to have two witnesses.
Okay. I see. We still go ahead and do that portion of it.
Yeah, I was talking about moving the title. Then you got to claim the title first and then move it. So.
Yes. Well, man, this is great stuff that we're all talking about, and it seems like you're putting the ass in ambassador on that. You're really putting out some information. Anyways, thank you, Christian, and I'm back here, and hopefully I come up with a better question. Thank you.
All right. Good questions. Thanks, Carlos.
Just call me Beaver.
All right.
It's probably easier to remember.
Jacob, you're unmuted.
Okay. If we, you know how slow I am. If we go back to the escrow signing, and we had a credit application or mortgage contract that was preceding that, your statement earlier about how we gave them the authority to issue the grant deed to send to us once they sent the trust deed over to the county. So that I'm trying to reckon that comes from the mortgage contract. That we gave them the right to drop the grant deed and send it to us as our thank you receipt?
Yeah, when you fill out the application, that you give them power of attorney, implied power of attorney.
The loan application, Christian?
Yeah, with the loan application, you give them all kinds of implied power of attorney rights, and then I think you probably did sign a power of attorney for the escrow agent, probably.
Okay, so maybe there too. Okay. So, anyway, we're at the escrow, and now there's a trust deed and a promissory note, and they send the promissory note over to the bank, and they send the trust deed over to the county. I guess when they send the trust deed to the county, that somehow triggers something for the county, because we didn't have an agreement with the county.
Yeah, you did. You got a trust indenture.
So they're making a trust indenture?
Yeah, you got a trust indenture.
Okay, so they send it. So let's say this is January 1/2004 that I get this grant deed from the county. Okay? And let's say the deed of trust went, or let's say this was, let's say this is January 30th, and the county got it on January 1st, so there was 30-day lapse. Is that okay?
Right.
So I want to express a grant deed to set the records correct in the county on the same day that the county got the deed of trust. Or I could do it on the day after, where I want to correct the records in the trust that they've orchestrated in the county. Rather than having to go through all that meets and bounds mumbo jumbo, can't we just get rid of the mortgage deed in the county?
Merge the titles.
Because they've already said, huh?
Merge the
and
titles.
Which title would I merge with it?
The equitable with the beneficial.
Merge it with what? Okay, but the thing is that to me it appears. No, to me it's just a recording. They sent the actual document over to the bank, supposedly to attach it with the promissory note, so that it's a security instrument with a note that makes it complete over there. So this is just a.
What's it a recording of? It's a recording of a grant deed. It's a recording of a trust. Now, who's the parties in the trust?
Trustee. A recording of. Okay, recording of a trust. Okay, I follow you. So it's a recording of a trust. Okay, and it's the legal title?
Well, no, you have to find out who the title people are, or who's the trustee, because the trustee is the one who's got the legal title. Who's the beneficiary, because the beneficiary's got the beneficial title. But anytime you take the two titles and merge them, the trust terminates.
But the mortgage, the deed of trust that they recorded in the county that has the lot, block, and address description that they're actually foreclosing on. That's what the trustee is foreclosing on. So I want to get rid of that document. If I make up a grant deed and I put a date before the grant deed that they issued versus putting a date on the grant deed after the date that they issued the thank you receipt,
what does the grant deed do?
Huh?
What does the grant deed do? The second grant. Now, we got a lot of feedback here on this line, whatever system you're using here.
Okay, go ahead. I moved the microphone. It shouldn't be there.
Yeah. The grant deed is, what is it doing? It's a mechanism and it's doing something. You're forming another trust. You're moving the titles.
Another title. Okay, I'm forming a new trust. Or am I expressing the trust of the closing?
Yeah, well, you're kind of leapfrogging over the one, but you're changing positions of the titles. Like, who's got the titles and what is the title position on the previous trust? And now where are you moving them?
Well, okay. The previous trust, the one at closing where the bank had the title company as a beneficiary, the promissory note went to the bank, the title company sent that over to the county sent that over to the bank. So the bank has both the trustee and the promissory note.
The county trust. The one that was set up with the county.
Yeah, the county trust.
You got to find out who.
Okay, so what title?
That trust, on that number one trust in the county. And you're going to form another trust. How are you switching those positions around on a new trust compared to the ones in the county? Look at
Well,
your tax.
I'm going to withdraw the ones in the county.
You got what?
I'm going to withdraw that deposit from the county.
But think about
And
the
I'm going to
titles.
make a special deposit of my grant deed.
You got to think about the titles. Who's got equitable title and who's got beneficial title, and what title you withdrawing, and where's it going from there? Where's the title getting moved from and to? And the relationship to who they
Well, right
are.
now, I'm working on.
Trust-wise.
Okay, so can you help me with that? I've got a trust deed in the county, and I've got a grant deed that they sent in the county. So what titles are those? Is that the county is beneficial? They're receiving payments from your taxes. They got to be the beneficiary of that trust.
Put it all on a diagram on a board or a piece of paper or something, and label the party.
I've got one right here. I'm looking. I've already did. Yeah.
Then you're forming another trust, and where are these titles going from the other trust into this new trust? And are any of those entities the same entities?
Okay. Well, I'm looking at the county being a separate trust. I see the county as being the beneficiary because they're receiving the payments. They're receiving the benefit. The grant deed, I don't know what the grant deed is. Maybe you can help me with the grant deed.
I don't know
that
either.
They issue.
You can't tell me. I can't tell you what the grant deed is. You're the one. I don't know who. It's got to be the. You got to know who the parties are. If you can't tell me who the parties are, then I can't tell you either. I didn't make out the trust.
Okay. So the grant deed, you know, apparently you can look at.
Why are you trying to do this?
Why am I trying to do it?
Yeah, why are you trying to do this?
No, I'm trying to see what the effect is of when we put a grant deed in, like we're talking about tonight.
Okay, put it on a blackboard, put it on a piece of paper, and then just keep thinking one thing. Anytime you merge both titles in one entity, the trust terminates. Now look on your diagram and see if you've merged the titles in any one entity.
I've got my I drew the diagram before I asked the question. I have it right in front of me, the diagram.
Right. Okay.
And that's what I'm looking at right now. So I see the. Well, am I correct to understand that the mortgage deed of trust that was given by the trustee, the title company, am I safe to assume that because the county?
What does the title company have to do with anything in this?
Well, there's a trustee that gave it to them.
Who is the party on the first trust in the county? And what does it have to do with anything in escrow closing? Title company.
Well, it has to do with the grantor issuing it.
Who's the grantor?
I am.
No, you're not. You better look at your deeds again.
Okay.
Because I guarantee you the one that went in the county per the bank, per the escrow closing and all that stuff, that you're not the grantor on that at all. The person who sold the house is the grantor. You're the trustee. And the county's the beneficiary.
Okay, yeah, that's right. The seller's the grantor. The buyer's the grantee.
Now, has that trust
This is the grant deed.
Has that trust got to do anything with the escrow closing in the bank? Where are their names on that? Are their names on anywhere there? Then have they got anything to do with this? Now you're
So if I record a grant deed,
already recorded. Bank always records them.
yeah, but we were talking. Yeah, but we were talking tonight about recording a new grant deed.
That's on another trust.
And so I don't have to be concerned about the other trust that there was a grant deed?
Well, that's what I'm saying. You got to tie these two in. Where's the title, the legal title on the county trust, and where's the legal title on this new trust you're talking about forming? And what's the relationship to the parties? Is any one of those parties holding both titles? Then you come back next week and you let me know.
Okay.
Got some other callers in line.
Okay.
.805, you're unmuted.
Okay. Hey, thanks for having me back again. I wanted to try and connect with Carlos. I think Carlos is in the California area. I don't know if he's offering any ambassadorships, but it seems like he's getting there. So I just wanted to put that out there. I don't know if he has a Skype.
Carlos is on? Yeah, go ahead. I'm Carlos too. Yeah. Carlos, you're unmuted too.
Yeah, I'll give you my Skype. Trust law. Okay. Capital T and capital L.
Trust law.
Trust law. Yes.
TRUSTLAW, and then what was the rest of it?
Trust law. That's all.
Oh, trust law.
Yes.
Okay. Are you in California? Not that it really matters, but
I'm in Santa Clarita, Valencia.
Okay, yeah.
Santa Clarita.
Yeah. Great.
Yeah.
Yeah, I'm in Ventura. I'm not
Yeah,
too far.
I know where you're at. Okay. Yeah, Skype me. No biggie.
Great. Okay, I'll do that. And then, Christian, I got one other question for you.
Okay.
And I wanted to ask something, Christian, in a bit. I'll let him go first. Thank you.
Go ahead. You can go ahead, Carlos. It's fine.
Well, I wanted to say I love Jacob. He makes my life harder. He makes me think, but good. What I wanted to share with you, Christian, I think you already said this regarding land trust, going back to land trust. In my opinion, one of the best things about a land trust, besides asset protection, and besides if you die, nobody gets it except the person and nobody knows you died. Because, well, everybody knows you died, but the trust did not die. We went through that. But to me, the most important thing is that if you sell a property, nobody gets to know. And if nobody knows, you don't pay a lot of stuff that you're supposed to pay. See
yeah, if we only knew, and we wouldn't have to give 60% of our assets away to the state.
Yes. Well, the point it is, I know someone close to me, real close to me. Actually, he's my twin brother. He sold a business for $1.3 million. And all I had him do is an assignment of beneficial interest. Done.
Yeah.
Done. All right. That's why I wanted to bring it up in case I didn't bring it up before.
Like Sony bought the Empire State Building.
Yes. Yeah, you brought it up the other day. Thank you.
Thanks, Carlos. That was good.
Okay. Hey, Christian?
Yeah, go ahead.
So a counterclaim, for example, you put that in, and that comes out on top, so that they have to deal with your counterclaim before they go back to dealing with their claim?
Yes, unless you open the door and start arguing their claim.
Right. So they're just going to make an offer to you to try and do that, and you just got to stick with your.
What's that got to do with my plea, my counterclaim? Where's that in my pleading?
Right. So in a procedure, in a court case, would that probably be the first step, is just writing the counterclaim and turning the counterclaim in? That really is the first step before you do an NOI or anything else?
Yeah, you're going to have to come in, unless you've been dragged into court. If I was going into court, yeah, it would have to be against a counterclaim.
Well, what if they've already given you a indictment or information or, complaint?
Oh, then I'm going to turn it into the counterclaim.
Right. So you just basically take every single point and rebut it, sort of, and write a counterclaim, or you ignore it.
That's an answer to their claim.
Yeah. Okay.
The counterclaim is going to present my case, my rights that have been violated because this guy didn't do his duty under the trust.
All right. All right. Yeah. So you don't answer it. You just write a new claim.
They got to
put it on top. Yeah.
They have to. And then you have to pay the fee and get it served by summons to them.
Got it. Okay. All right. That answers my question. I'm going to start writing my claim.
Or we could simplify this and just do a show cause here and come in with a. Anyway, that's a different scenario we're trying to work with. But anyway.
Okay. All right. Well, I'll be on Skype. Thanks a lot for your help. I appreciate it.
Okay. Thank you.
Okay.
That's it. Okay. Great. 1:11. Well, I'll say good night, all. See you tomorrow at 10 o'clock.
Q&A session is over.